Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dahil mihi Anglican for his verbal talking. I didn't ask you to interrupt me.
Is that correct?
All right, I think I'm ready. I think we're good. Good morning. Welcome to the Court of Public Opinion. Thank you, sample user. I'm the Recovery Addict. Thank you very much. Welcome, Woody. First in chat today, not sample user, but Woody. Congratulations, my friend. You, through your over-exuberance, being here first and blabbing about it in chat before anyone else was ready to talk, you've earned yourself a punishment. My friend, we're going to punish you with internet ownership. That's right, we're punishing you for being first. You have to take care of everything IP-related worldwide. And just do it in addition to all your regular duties, and there will be no problems. That's what we say. It's a big thing for you. It's a small thing for us. Congratulations, Woody. That's a great win. Great win. This goes on your permanent record. Make sure you download, digital download, a copy of your crime, or at least a certificate commemorating this occurrence by going over to the YouTube shopping page and scroll until you find the Internet Ownership Certificate, which comes pre-signed. Fill in the blank. You just add your name. It's signed by both me and my boss, Mrs. R.A. So it is suitable for framing or hanging up on the wall. Use as a cover sheet on your CD as well. All right, I'm just trying to get my head in the game this morning. I've got my fingers crossed. I'm going to go get my neck worked on later tonight. Later tonight to try to fix my arm. I've got a pinched nerve in my neck that... Okay, here's how bad it is. I occasionally lose all the feeling in my hand. Like, it works just fine. But I knew it was a problem because I went and I was helping Mrs. Ari in the kitchen, and I picked up the lid off from the stove and stirred, and I put it back down, and I didn't realize I had burnt my fingers. I could not feel that the pan was too hot to pick up, and so I burnt these 3 fingers. I figured I need to do something about that. I might do just a little something. Okay. Please get an MRI. Oh no. MRI's out of the budget. We're going to work a little bit first. I know exactly where it's pinched, so we'll get it figured out. Did she have you stir in the gravy? Always. She's like, hey, I've got a sucker. This one will stir the gravy for hours. We're going to cover some details of Karen Reed. I can't tell you if we're going to cover the entire thing. We have, there's Sharon. Thank you very much, Sharon, by the way, for this. Appreciate this, the hard work you do every single day. It means so much to so many people. It really does. Sharon, you make that possible. I appreciate that. Yes, Ian's crew reached out to me on Insta regarding the pins. That was my problem. I forgot to tell people that I'd never check Instagram, but they did send me an email subsequent to that, so those are going out priority mail today. So our auction items are going out today, and they're shipping to 2 states. It's not going to Canada, thankfully, so they're going to be pretty quick. You should have them here shortly. With the holiday, I'm not sure if it'll be this week or next, but anyway, thank you, Lula, Pat, appreciate that. I still have not read that message on Insta. I'm not even sure how to get my Instagram messages, but I did get the email. So those are going out. All right, let's see. Happy birthday. Let's see where the happy birthday is. We've got Shark. I think it's Shark. Is it Shark? It's not Shark Q, is it? You don't have my address? I was given an address to ship to because it comes through Tide. So I was given the addresses to ship to. But are both celebrating their special day with us. Oh, let's see. Shark and Cameron. Pronounced Shark. There you go. All right. We're going to sing to Shark and Cameron, which I just clicked off it, so I need to go find it again. Hang on. It's way up here. Birthday forms were closed, and then it came in right here. Boom. There it is. Found it. All right. Let's go ahead and sing happy birthday so we can get our day underway. What is wrong with... Do you guys see this? Why am I like so short? I need it to be like that. But now my box is off, so I have to reshape the box. Let's sing happy birthday, and then we'll reshape the box. Is that okay? Let's do this here. Okay. Everyone stand up, take a deep breath. Shoulders back if you can. Oh, feels good. Take a deep breath. Let it out. Remember to project your voice to the back of the room. Blend your voice with your neighbors. Warm up with me if you will. La 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 la. I was singing this morning. I was singing a Pearl Jam song. Might share it with you later. All right, here we go. We're going to sing happy birthday to Shark and Cameron, who celebrated their special day today. Happy birthday to you. Happy birthday to you. Happy birthday, Shark and Cameron. Happy birthday to you. Celine, we can sing to you tomorrow, for sure. 100%. We'll be here. Happy birthday, Cameron and Shark. This is your special day. Thank you very much for sharing it with us. There are millions of people and millions of places you could have been instead of here, but no, you're here with us. Privilege and pleasure is all ours. Help yourself to free pancakes at Denny's, IHOP, Waffle House, Walmart. No, Walmart doesn't have pancakes. McDonald's. You can see where I got confused there. Why did Walmart come in? There's always a Walmart. Will we be here on Friday? Maybe. We'll see. Jen D says, thank you. I'll tell Cameron he'll love it. That's awesome. Cameron, happy birthday, my friend. Dancers are doing their thing. Walmart has pancake mix. No, but it's not free. I can tell you from watching a lot of videos, trying to get it for free, they will get you. They will get you. No free pancakes at Walmart. Although, technically, if there's a McDonald's in the Walmart and they honor the free pancake rule, which I don't think they do, then in a way, you can get free pancakes at Walmart. So it's worth a try if you don't mind adding a little bit to your rap sheet. Just saying. There's your warning. Happy birthday, Shark and Cameron. Hope you have the best of days. It's your birthday after all. Thank you for sharing it with us and letting us sing to you this morning, as it makes our day better as well. So we're going to finish with the big drum solo here in just a little bit. Here we go. Air drums at the ready. Beautiful finish. It was great. Thank you very much. All right. This is a weird day. We've got what? We've got all sorts of things going on. What is it this morning? Is it? I have to switch over to something else. Hang on. I should have had this ready beforehand, but I didn't. We have our motions for Karen Reed, which is probably what we're going to watch most of, unless it gets incredibly dull. Incredibly dull. There's not a lot else going on. We have all the small courts are in action. So you've got I think Fleischer's going to be live today. Judge Middleton's live. We'll probably see Judge Simpson if it gets slow a little bit. Judge Boyd should be up. All of them are happening, but there aren't a ton of big cases going on to follow that we want to see. So we've got a little bit of a lull. Is sample user real? No, it just comes up every time I open this chat window over here. It comes up down at the bottom as like, and I guess it's because some people open up the chat window and they're not fortunate enough to have people in chat. And so the program just says, if you did have people in chat and they were talking, this is what it would look like. So that's what sample user is. But I have been blessed beyond what I deserve to have people in chat. So we're all good. Where's the cat? The cat's outside where it belongs. It is an outdoor cat. As demonstrated by his claws, which I think have morphed. They're now beyond claws and they're in the talon stage. I think they can he can put his claws out and completely just like an eagle. He's got little scratchers on him. It's court light this week, that's for sure. Court light, but it gets court heavy. Yesterday got heavy. I do apologize for that. I should have bailed on that before I did, and I apologize. I will spoil it for you. Susan Lawrence, the bad neighbor trial, got 25 years, which is 5 years less than the max for shooting and killing Tatiana through the locked metal door, as we heard over and over in the victim impact statement. Does he let you trim his nails? No. He doesn't let you touch his paws. The paws are no touchies for him. And if you do touch his paws, he'll remind you that he has nails. He'll just do you know how you play the game when you're kids where you put your hand out and you put your hand on top of it and you stack like that? He does that game. Only when he plays to win. So you put your hand on his paw and he goes, and he just holds you. He doesn't claw. He just point. It's like, hey, I could if I wanted. And then you can't move because if you do move, he'll dig. He's like, he gotcha. So, let's see. We could go back and watch Jose's sentencing that we missed. It's really fun clipping cats' nails. You should try it at court. I've seen videos on YouTube about this. It's not fun for the cat or for the person who's trying to keep the cat from climbing up their arm. I don't remember if there's a parole opportunity for Susan. Let's see. Angelique, we will have our live view at the Sarah Boone sentencing. So I won't have anybody in South Carolina at the time. Yes, the judge jumper is being sentenced today as well. Here's my problem. There is a company that thinks they own the rights to the judge jumper video. And if for some reason that's shown, I get hit with the copyright claim that is a bear to fight every single time. It's like the court sold the video rights. I don't know. I'm using it as an example to one of those little YouTube short video companies, and they are highly litigious in protecting it. Let's see. I cannot trim my cat's nails, by the way. I cannot, because it is an outdoor cat. He hunts squirrels. He hunts and kills squirrels. He's a beast. He's a beast. He loves to he's got a taste for blood. I don't know. Birds, mice, squirrels, it's all fair game for him. And we have a ton of squirrels, so there's a lot. The squirrels, quite honestly, could hold their own. I mean, they can bite you really, really fast in a lot of different places, and scratch at the same time. They're vicious little animals. They're not good pets unless you've raised them from when they were very little. Anyway, the good news is he does not bring us his kills, which we're happy about. So he consumes them himself. He's doing normal cat stuff. Yes, he is. All right, we have a couple things going on. We have 40 minutes until Karen Reed. This is going to be a motions hearing. Let's see. These motions, what we talked about in the Karen Reed before, I think you're getting just maybe get some rulings on some of these. But they're trying to get additional phone records, like from her dad and mom. I think maybe just her dad. But this hearing will go into that and see if they get those. The state wants them, right? Let's see. Has he been taken to the vet for his shots? He got taken to the vet for his big day. I can tell you that. He's a shared cat, and he's been cared for at the vet. That's what I can say. The other family does the vet stuff. He got in a fight early on in his young outdoor career, and got a good scratch on his paw. Got cut open, and so they took him to the vet. He was gone for a day or two. Came back with a nice shaved area and stitches and all that. And but he did get picked up and get his ear nipped. So that happened. Don't think he's chipped. Had to. Yeah. I'm not going to do anything to the cat. I'm not going to because he's not an indoor cat. He's not clawing on our stuff indoors, and that's usually why you would probably trim their nails a little bit. But do you go home for Thanksgiving, or you have Turkey Day at home? We have Turkey Day at home. We might be inviting some people over. What does the ear nip indicate? That there will be no little Kikis. That Kiki is the last of his line. His progeny ends with him. That he was broken previously, but now he is fixed. All indicated by the clipped left ear. They do that because, our town has like a no-kill policy for pets, but you can quickly have way too many stray cats and wild cats. Kiki got picked up as a stray and got fixed and released. It's a catch and release process. All right, where are we? We're going to go to I think Judge. We're going to go to Michigan. Let's see. Judge Middleton is up and awake. Very dismal room there, white and gray.
Solar panels.
Hey Josh, I watched that timestamp and I had like no audio
for Tanya Watkins.
Like nothing happening for 10 minutes after that. Was that the right part? It was just a guy sitting there with nothing happening. Is that the part where we're to watch? I did sort of jump around and scroll through, so if he said something, I missed it.
Apparently not. She's on camera also.
You sent me 18 minutes, 34 seconds. Was it a different timestamp?
Pretty exciting. We drove all the way here for this little brown room. Little brown room with no windows in it.
Oh, he's got visitors.
Take up our next case here.
He's got
There
visitors.
is a jury trial upstairs today. There is a jury trial upstairs today.
Oh, is there? What is it?
I forget who has it. I think it's just a simple possession of methamphetamine.
Who's doing it?
That's what I forgot. Ross? Maybe?
Good morning. Are you Christopher Salt?
Yes, sir.
This is Judge Middleton. I haven't seen you in a while, but I'm here.
I've never
You're
been anywhere.
You're charged with unlawful use of a motor vehicle. The file number is 241862.
When they put me
There
in, they
may
said
be
I
some other.
only stolen vehicle, and I didn't understand that. Because I was told it's just a misdemeanor.
Well, it's a high court misdemeanor.
Okay.
Auto theft, sometimes known as UDAA, unlawfully driving away an automobile of another, is a felony punishable by up to 5 years in prison. Unlawful use of an automobile, sometimes known as joyriding, is a high court misdemeanor.
Okay.
It is alleged that you borrowed a U-Haul trailer from a Porsche Cazor. She had rented it from the rent-to-own place on 131, and you failed to return it. So that's taking possession of the vehicle lawfully, but exceeding the lawful use of it. That's what's known as unlawful use of a motor vehicle or joyriding. She rented it on September 2nd. This could be your uncle. You asked if you could borrow it, and you borrowed it, and then you didn't bring it back. And then they issued this warrant. So I can't tell from what I'm looking at what happened to the truck. U-Haul has been plagued by out and out theft. The rent-to-own place, somebody rented a Bobcat and never returned it. And the prosecutor, they're still mad at me every time I go in there because nobody charged their stolen Bobcat. But generators, other things, people rent and then don't return it. So I don't know if this truck was returned or not.
Yes.
How did you come to get arrested?
We got pulled over in Portage. We're on our way back to return it. It was a couple of days late. I had texted my niece that we were going to be late, so we were on the way back to return it. On it, but
all right, we'll get to that.
All right, so
we'll get to that.
All right, so you got arrested actually in the truck at some point?
Yeah, we were headed back to Three Rivers to drop it off. She rented it for my girlfriend to help.
All right, well, don't say any more about it
at
this point. But how did you get arrested last night?
I was standing outside of Myers, and the officer knew me from Sturgis. And while I had a warrant, he told me for Branch County for a show cause. And then he seen the other warrant. And I had no idea that I even had this warrant because, like I said, I wasn't the driver, I was the passenger. I just wanted to help her move.
All right, well, we'll find out more about that. All right, where are you still living on Lester Road in Bronson or Leiter Road?
No, I'm living in West Chicago in Sturgis.
Live where?
West Chicago. 960 West Chicago.
Okay. I don't know why my internet's not working on this computer.
All right. Now I was told that you had another charge.
I got a show cause warrant in Branch County.
But I was told there was another charge here, but I don't see it.
No, I was just told this charge when I got booked in.
I'm having trouble understanding you.
I'm sorry.
That's all right. Maybe it's me.
It's not. Just pound on the keyboard today.
You don't really have much else.
Okay. I mean, I was surprised when he told me about this one.
Right. How'd you happen to be in Three Rivers last night?
No, this was in Sturgis.
Oh, in Sturgis?
Yes.
What's the show cost for in Branch County?
Just unpaid fines. I've had trouble with my disability. I finally got it straightened out. I set up the payment plans with them, but court thing. But I missed the show cause hearing. But like I said, I called over there. But my payments are $25 a month, which I'm gonna get my back pay on my disability and go ahead and pay them off.
All right. Well, that's between you and them. This happened in October or September. So when they pulled you over in the truck, did they take you to jail then or just let you go?
They took me because I had that warrant in Branch County from previous by another show cause for the same thing, but they just took me over there and released me in Coldwater. But they never told me anything about charges coming for this, for me. They told my girlfriend that they were sending it to the prosecutor and that it possibly be charges coming back on her, but they never said nothing to me about it.
So you were actually the passenger in the car?
Yeah, I was good. That's it.
But are you Miss Kazor's uncle?
I'm her uncle, but yeah, my girlfriend talked to her and set all this up because this
all
was
right.
to go.
Okay, don't say any more.
I know.
All right. You don't have any cases here. You don't owe any money here. This is a high court misdemeanor charge.
May I say something real quick? I mean,
yes.
I've got a lot of medical issues and I've got some plans coming up with my cardiologist here in a few days. I don't really have money till my disability. I mean, not like which I've lived here my whole life. I was hoping maybe possibly I could go take care of that one because Friday I got to go see my cardiologist to set up get stents put into my heart. And like I said, I don't really have much family or anything like that.
Well, there's a lot of salts around here.
Yeah, but I mean, I'm not related to all of them.
All right. Well, they're probably happy about that. All right. Let me, I'm going to set the bond at $2,500
Judge
PR.
That was a low blow.
No drugs.
They're
no
happy
alcohol,
they're not related to you? Oh, my goodness.
No contact with True Value Rent to Own. No weapons, no assaultive behavior. I'm going to appoint an attorney. I'm going to set PEC for December 10th at 8:30 and a preliminary examination if needed for December 17th, 24 at 1. This is a nonviolent offense. It's a high court misdemeanor. You probably didn't even realize they had a warrant for your arrest. If I understand correctly, you weren't driving it, but this isn't how it works. Somebody rents a truck, you borrow it, and then you just keep it for a few days. It's got some problems. And I'm not sure where you were when you got pulled over with the truck.
Portage.
What?
Portage,
well, don't
right
tell me, but that ain't close to where this is. Like I said, I'm having trouble Reminds me of the character in Blazing Saddles. It said the sheriff is near, and nobody could understand what he said. But I think we got it. So I've given you a personal recognizance bond, $2,500. Appointed attorney to represent you and set the bond for December 10th, set pre-exam for December 10th at 8:30. The sheriff department is under construction, and they're asking us if we could kind of limit the number of people in jail. I did cash or surety bonds on the last
sheriff.
two guys.
Jail's under
But
construction.
you're local. I've known you. This is a high court misdemeanor. Can't tell whether your girlfriend was charged. I'll have to look that up. Will someone come pick you up?
Yeah. I don't know if I gotta go over to Branch County for them to PR by me like they have been or not. Or
Yeah, but defendant also has a Branch County hold.
just take me over there, book me in, and let me go.
All right, well, I don't know about that, but we'll sort this out. When you get out of jail, either here or there, I want you to call your attorney and make an appointment, discuss this with them. I'm not so sure you're going to bop right out of Branch County Jail. Judge Weigel probably isn't very happy about this, and Judge O'Grady probably isn't either. So, at any rate, you got a PR bond here. They can take you to Branch County. You can deal with your cases there. Your next court date here is December 10th at 8:30. All right, Mr. Salt, you're good to go.
Thank you, sir. What's okay?
Thank you, Deputy. The sheriff is near. Sorry.
Can't understand it.
All right, thank you, Mr. Stickley. We have a couple people that didn't show up. Jessica Quintana on 2 ordinance charges from 3 Rivers has a long history of not showing up. And we just talked to her. I'm going to do a bench warrant for her arrest. $500 cash or surety. Miss Quintana, if you hear this, you need to stop calling up. You need to get in here and deal with these charges of retail fraud and disorderly person. And they told you on November 4th that you needed to appear. File 24561. Macon or Morgan Dwayne Macon Riley, no operator's license. Pled not guilty. She was trying to get her permit. That was set for today. Reset. Then she was given a notice at the counter. I'm going to do it. Order to show cause before we do a warrant on that one. All right, that takes care of our jail arraignments, bail arraignments, arraignments, pre-trials, and Mr. Stickley, I think that's everything we got. All right, that may be it for this morning. Keith, thanks for sticking around. It's good sometimes just get these over with right as part of the morning
100% agree.
calendar.
Until 1 o'clock when they give us another list of 17. Cross that bridge when we get it.
So far, that's all I got. And I'm going to shut off my live feed.
I just got that new charge for dance.
Oh, yay.
Yay.
Yeah, let's do it now.
I'm processing right now, so give me a couple minutes.
All right. Okay, I'm going to stop the live feed for a minute. We're going to have another concern problems are, and
And he's gone. All right, we're going to hop into Judge Cedric Simpson really quickly. We will be joining and following the Karen Reed thing as it begins. We won't going to miss any of that, so hold tight. Let me find Simpson's. There's Middleton. Lots of other videos that are not him. Judge Cedric Simpson.
Versus Daryl Hicks.
Oh, man, John Cahill looks like he's had better days. Poor guy. That does not look like fun.
Good morning, Your Honor. Marcia Cratcher on behalf of Mr. Hicks, who's approaching. Mr. Hicks, can you please state your name?
Hicks. Thank you.
Your Honor, we would be asking for a preliminary exam of this matter. Discovery is, my knowledge, complete. According to, I'm sorry, sir.
Oh, you were not done talking. Go ahead.
Hey, Kurt, I'm not on StreamYard.
I would believe we're requesting a half a day exam, so I don't know if the court would want to put on a special day or on a Tuesday.
People have their witnesses available on
I did watch you on Ian Runkles last night.
Should.
Runkle of the Bailey.
What I will do in this instance, I'll set preliminary examination in person, December 10th, 2024, 9 a.m. before Judge Burke. What I would suggest that you do, if you think that it's going to interfere with that schedule, is contact Judge Burke's office and see when he can give you a half day.
Thank you, Your Honor.
Thank you.
Thank you.
Court calls case People versus Hanzo.
Definitely, Kurt.
Your Honor,
sounds good.
Joe Simon on behalf of Mr. Joe. Mr. Joe, state your name. Joe.
All right. You're requesting an adjournment for immigration issues.
That's correct, Your Honor. And Your Honor, Ms. Barroso tells me that we should probably request at least a month for that.
I think that.
Why did she tell you that?
It has to
Not
go.
Barroso either.
Oh my goodness, I did do that. I fumbled.
You should.
I'm sorry, Ms.
You need to
Bassan.
apologize.
I do apologize, Ms. Bassan. I know better, too. Sorry.
I don't, and I'm still getting used to it, and that's how I knew who you were talking about, but it's pretty bad.
In any event, there's a protocol that I understand needs to be followed that would require that amount of time.
Probable cause conference, December 26, 2024, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Wait. Court does call the case People versus Ryan Atkins. Whenever you see them,
And her children are praying on behalf of the people, Your Honor.
regardless of whether they're free.
Well, Your Honor, Assistant Public Defender Carson Lobesi on behalf of Mr. Ryan Atkins, who is present to my right. Mr. Atkins, could you go ahead and state your full name for the record?
Pardon? Go ahead.
Good to see you, Your Honor. Your Honor, at this time.
Long time no see. Where are they? Where?
14A2, they got me over there.
Oh, okay. All right.
In the cave over there.
Whatever you want to call it. Go ahead.
Your Honor, at this time, we respectfully request you to set this for an exam.
All discovery is complete.
To my knowledge, yes.
Will the people have their witnesses available 10th?
That's fine, Your Honor.
All right.
I have to send out my coins today for
Preliminary examination in person will be set December 10th, 2024, 9 a.m. before Judge Barr.
Thank you, Your Honor.
Thank you. Bond will continue.
These?
Hey, Mr. Bubasi, Mr. Atkins probably let you know, I'm holding him on another matter.
Yes.
So that once that resolves, somebody should contact my court to let us know.
These are challenge coins.
Court does call the case. People versus Matthew Menke.
Ready, Your Honor.
They work as pog slammers, though.
It's poison.
Your Honor, Joe Simon on behalf of Mr. Menke. Mr. Menke, can you state your name if you're unmuted?
Henry Ford.
Matthew Menke.
Henry Ford Health.
And Your Honor, Ms. Poisson and I have accomplished a great many things, including a resolution of the case. You should have a plea sheet. Mr. Menke was not able to, since he is in a treatment facility, was not able to return an advice of rights executed and a sentencing judge waiver, but I got him both of those forms and discussed them with him. He's ready to enter his plea accordingly.
The plea form indicates that the defendant would be pleading to count 4. He's pleading as to the charged count 4, domestic violence, second offense, as well as to count 5, police officer resisting an attempt or attempted resisting and obstructing a police officer, both 1-year offenses. Upon his successful plea to that charge, counts 1, 2, and 3 would be dismissed. That's the court's full understanding of the agreement.
There's one other aspect.
Parties are agreeing to no upfront jail. However, this court cannot bind the sentencing judge.
Correct. And my client understands that, but that is a killer group between the parties. Yeah.
Sir, will you please raise your right hand to be sworn? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
State your name again for the record, please.
Matthew Menke.
All right. Sir, it is this court's understanding that you're going to be pleading guilty to 2 misdemeanor charges. Is that correct?
Yes, Your Honor.
The first is the stated count 4 of domestic violence, second offense. That is a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that?
Yes, I do.
The other charge is the charge of attempted resisting and obstructing a police officer. That is also a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that?
Yes, I do.
All right. Sir, you also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A4 District Court. You understand that?
Yes.
I need to go get some bubble wrap. I'll be right back.
Do you still wish to plead guilty to these charges?
Yes, Your Honor.
To the charge of domestic violence, second offense, how do you plead?
Guilty.
To the charge of attempted resisting and obstructing a police officer, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind?
Yes.
Although you've gone over an advice of rights form, you understand that by not having a trial, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand all of that, sir?
Yes, I do.
You understand you're giving up your right to appeal of right?
Yes, I do.
Are you on probation or parole?
No, I'm not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily?
Yes, I am.
Of your own free will?
Yes, I am.
And because you believe that you are indeed guilty of these offenses?
Yes.
October 12th, 2024, at the location of 9359 Harbor Cove, apartment 254. What did you do on that date involving a Bailey Vanderweel that makes you think that you're guilty of this offense?
We were in multiple arguments, and I know I ended up.
Let's say what you did, please.
Okay, I was mad at her and her boyfriend, and I just made some threats, and then I ended up shoving her.
Okay, so you pushed her without her permission?
Correct.
And you did that purposely?
Purposely. I was drunk, but yes.
Although having had some intoxicants, did you know what you were doing at that moment?
I do remember some of it, you know, and I feel like,
Mr. Mankey,
Uh-oh.
as we discussed yesterday, you have to be unequivocal. You intended to push her without her consent. Is that correct?
yes,
And I think more importantly, at the time that you did that, you knew what you were doing.
yes.
Who is this individual to you?
She was my girlfriend, and then probably like a month to 2 months before we agreed on a breakup, but we were still living together.
So, okay, so she was in your household, you were in a relationship prior to the breakup.
Yeah, that's correct.
Okay. Had you previously been convicted of a domestic on or about July 19th, 2021?
Yes.
Yes? Okay. Did you come into contact with police officers on that day?
Yes, I did.
And what happened when you came into contact with officers?
I didn't let them in for about 5 minutes into the apartment, and then I finally let them in, and then I just didn't follow commands going down right away.
Okay. And you knew they were police officers?
Yes, I did.
And you knew they were in the lawful performance of their duties?
Yes.
Okay. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's pleas of guilty to counts 4 and 5. Counts 1, 2, and 3 are dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing in this case will be
At 9:30 before Judge Fresh Hour.
December 5th, 2024, 9:30 before Judge Fresh Hour.
Your Honor, regarding bond, the people and I have come to some agreements. We hope the court will also adopt. My client's insurance goes week to week for his inpatient treatment. We fully expect that to expire at the end of this week. And the date is uncertain, but it will be Friday or Saturday. Because of the parties' plea and sentence agreement, the people and I have agreed to the following, if the court will adopt, that he be allowed to have a personal recognizance bond, keeping his GPS tether with the 1 mile exclusion zone of the exclusion zone of 1 mile radius around the complainant's witness whose apartment, the same address that you just read is where she resides. And I can give a firm address where my client will reside in Brighton, Michigan with his father.
So it'll be a PR with a GPS tether with an exclusion zone.
Yes, he already has the tether presently to make sure he's where he's supposed to be at the treatment facility. But he will keep it and then.
So since we're changing the order, prepare a written order for the court.
Will do.
On that, and that way we can then do the community corrections order so that will happen.
Thank you, Your Honor.
All right, you need to get that in by the end of the day because Ann says she's leaving.
Do you want me to make this?
And I'm not allowed to do things by myself. All right.
Thank you, Your Honor.
In all other respects, bond will continue.
Thank you, Your Honor.
Thank you.
Thanks, Your Honor.
Court does call the case, People versus Jamison Boone.
Assistant Public Defender Jay Bellinger on behalf of Mr. Boone on both matters, Your Honor. Mr. Boone is. Can you please state your name for the record?
Jamison Boone.
Thank you. Your Honor, after a review of the files, it's my understanding that discovery is complete. We would ask to set for preliminary examination at this time.
On both cases, is that correct?
Yes, Your Honor.
People have their witnesses available the 10th. And
We'll
go.
do our best.
Preliminary examination will be set in person December 10th, 2024, 9 a.m. before Judge Burke.
Thank you, Your Honor.
Bond will continue. Thank you. Court does call the case, people versus Jillian Carey.
Children's attorney on behalf of.
Good morning, Your Honor. Michael Bavana on behalf of Jillian Carey, present to my right.
Your name, ma'am?
Jillian Carey.
All right. What are we doing on this?
Your Honor, we're going to be setting this for a preliminary examination.
I think we were looking and speaking with Mr. We're still hopeful that there may be an additional report from Detective Parvez, but we're fine with setting this if we could set this into January if possible.
You would agree with that, counsel?
Yes, Your Honor, the weeks of January 20th, particularly.
Well, you don't get to pick a week.
Or the 13th.
You don't get to pick. Judge picks. That's one of the privileges of being on the bench. We'll be jumping to Karen Reed here once that begins. We're going to be following that this morning. Those motions should be spicy. A little bit of fun.
And all discovery is complete. Is that correct, counsel?
Other than perhaps that report, yes.
With the exception of the materials that I requested and was denied, yes.
I don't know what that means.
Your Honor, you denied a motion to compel discovery last time. That is the material I'm talking about that I've not received and the court has not examined. So that will be the discovery that I'm talking about. But I'll pursue that at a different level. Your Honor has already denied my motion. So
what? Sour grape smudge?
I still don't know what that means. Do you have all of the discovery, counsel?
I have all the discovery that they've given me, yes.
And if I denied your motion, that would mean that would be something that you're not entitled.
I have all that they've given me.
That's the court's position. I don't agree with the court's position, and so I can't answer that question that I've gotten all the discovery.
All right, then I'm not setting it for exam until we're sure that discovery is complete. That's how we work here,
okay.
Counsel. So you guys figure it out. From the people's perspective, has discovery been completed other than the one thing you've indicated?
All right. Well, since we were last year in court, Detective Parvez did offer what I would call a supplemental report that has been tendered via email about 2 weeks ago. I also discovered there had been some body cams that hadn't been properly notified, like notice had been sent to my office. Those have also been tendered. So as far as from what is in possession of the people, everything has been turned over. The only remaining discovery that may exist that I'm aware of would be this additional supplemental report by the detective, but that investigation is ongoing.
So I'm going to try this again, counsel. You have all of that. You may disagree with this court's decision, and I could care less, quite frankly. If you want to appeal it, appeal it. The question is, in terms of what should be supplied to you, do you have everything?
I have everything that was described by the prosecutor, Your Honor. So yes.
He's not going to do it.
The people would have their witnesses available January 21st, 2025.
I don't see any reason why not.
Preliminary examination in person, January 21st, is it?
Yeah.
2025, 9 a.m. That's before me. And counsel, if you want to keep playing these wordsmith games, I'll go toe to toe.
Your Honor, I'm just.
Thank you. Bond will continue. We're done.
Okay.
Do you want to address it, Commissioner Bond?
Oh, I'm sorry. There's one more matter, Judge, to address. My client is currently restricted to travel in the state of Michigan. Her family is located in Toledo, Ohio. I would ask if she be allowed to travel over the holidays.
Prepare an order, get it to the court today. I'll sign off on it.
Thank you, Judge.
This is what I love about Judge Simpson. He doesn't hold his frustration with the lawyer against the client, which is what a good judge will do. I mean, a good judge doesn't do that, so that's funny. Okay, we're going to get ready to jump over to Karen Reed because everyone's coming into the courtroom. We've got a few minutes before they begin.
To say. Just let you know. Court does call the case people versus David House.
I predict some spice out of Judge Simpson today.
Good morning. I'm Pickles on behalf of David Alford.
All he needs is one more person to push his button, and he's gonna let loose, I think.
David, would you state your name for the record, please?
David Paul Ousley.
I was just appointed, sorry, I'm sorry. I was just appointed on this matter, but there need to be some further discussions between my client and the prosecutor.
Yeah, you need some more discussions. We'll give you some time to do that because we're going to jump over to Karen Reed, live in Canton. All right. Let's see. I'm loving it. All right, here we go. Hot mics. Got a couple minutes before the judge comes in. You've got the... Is that... You know what he looks like? He's a doppelganger. John's dad is a doppelganger for... Is he in Breaking Bad? Who's the celebrity he looks like? There's our defendant, Karen Reed. Big courtroom, you can tell from the echoes. The mics are hot. Bryan Cranston. No, it's not. Is it Bryan Cranston? He's the fixer guy. It's not Bryan Cranston, I don't think. Yes, Bryan Cranston? Not the bald cop. The guy who plays Mike. I think that's it. Is that Bryan Cranston? Yes, Mike Emmertrout. That's the guy. That dude. Is there not a similarity there? Bailiffs are ordering everyone to turn off their cell phones. I'm going to work on some audio here and see if we can get this turned up just a little bit. The balance is a little off. We're getting left ear, right ear thing. It's a little confusing. So we'll bring up mono. That'll help for those of you who are on a device that only plays one side of the audio. Jonathan Banks is the actor. Just for the record, I think he's a fabulous actor. I'm talking about his dad, not his brother. John's dad, not brother. The mics are hot here. Jump to a different feed here just for a second, so I can fix this audio as well. Now we're good. I'm not here. I'm back. I'm back. Sorry. Apologies. So, new special prosecutor on this case. Lally is riding a shotgun on this one. So he'll be opening the gates and everything, but all the heavy lifting done by somebody else. I think he's got the mute button backwards. He keeps pushing the button and we hear him talk. I think that's not intentional. Packed house in there. New lawyer from New York City to handle expert testimony. True Crime Kitty, they're gonna do some more research on the car. I think the new information is going to be pivotal in the new case. But they're gonna do a couple more off-chip analysis. They only checked one chip. There are 3 chips. They only checked one. Surprisingly, at the encouragement of the defense expert, who said that's all they needed to check, and it did not have the information they needed, at least not enough to really nail it down. There's Mr. Lally. They're hiding there in the background. He'll be sorting papers and giving a little bit of encouragement. We might see him a little bit. We'll see. What are we deciding today in these motions? Probably, if the judge decides to rule on anything today, this is going to have to do with Karen's dad's cell phone, and if that information can be extracted from the phone companies and used in court. The other chips contain firmware. I listened to that really carefully. I listened to the experts, and I think there's a chance they might have other stuff as well, not just firmware. I agree, the chip they got information off of, I think they got everything that was available there. But there may be more. Robert Alessi is the new New York lawyer. Yeah, I'm sure they'll allow it. Little pre-trial or pre-hearing discussion. Swearing him in? What's happening here? This is a hearing, yeah. Some of these hearings can go long and some can be incredibly short. And oftentimes they end without a resolution that we hoped, where the judge doesn't actually make a decision and says, I'll rule on it later, some other time. Have a good Thanksgiving. And then that's where we end. So I prefer a ruling from the bench if it's a sound ruling. ton of drama surrounding this case, a ton, and I think it's sad because I think it takes away from the case itself, and it causes confusion, and it causes people are fighting with each other that they normally wouldn't fight with over this.
Yeah.
We can disagree on different things and still be friends. Trial is going to be, it was, I guess, stipulated to. Both sides want the trial moved to April. Give them some more time. It's a big hanky. I think it's a full-on bandana. Hunt Lover, yes, we were watching that, and it got a little heavy, and we bailed on that. But she did get 25 years, 5 years less than the max. This judge will be out, but she's in for this trial, I believe. Like she's taking on a new thing, but she's going to be here for the trial. I don't know. Maybe if it gets pushed to April, would she stay in for that? I would not be crying over a new judge for the second trial. I'd be okay with that in a big way. This looks like the same courtroom. Our camera's just in a different position. No, different courtroom. It doesn't have the bench on the back where the media was. Similar layout, though. It was almost like a U shape. Iris, you haven't missed anything yet. We've just got a live hearing today for Karen Reed. It's going over some of the third-party information that I believe the prosecution is seeking, and that's the phone records of Karen Reed's dad. This is going to come in because, I mean, the importance comes in at figuring out what happened that morning, because there probably were some phone calls back and forth between Karen and her dad early that morning. And possibly even text messages. I know it's about third-party data, so not the victim, not the defendant.
Okay, perfect. I'll let him know.
Rolling with 7, yes. Karen Reed has been tried once. It ended in a mistrial, and how it ended in a mistrial is the subject of a lot of debate. The jury, by many counts, reached a conclusion on 2 of the counts that were being charged against Karen Reed, but not on the third. But the way they filled out the paperwork and the way the judge interpreted their responses or their notes to the court, they ruled as it was a mistrial on all 3 charges, which allows her to be tried again on all 3 charges. The defense fought very hard, saying, we've got evidence, and we think we can prove, if you allow us to talk to the jurors, that the jury did in fact acquit her on 2 charges, which several people purporting to be juror members have said that they did, and that she should only stand trial for the 3rd charge on the retrial.
Okay, perfect.
hunting around my office looking for a little tiny box. I found one right here. I need the box for the pins that I'm sending out, the slightly questionable pins, so they don't get damaged in the mail. I want them to arrive in pristine condition. Need a second box. Tisha, I have a call scheduled with my YouTube partner manager to talk about the issues you guys are reporting on buffering, which seem to be not widespread, but somewhat distributed amongst you all. Most people do not have the buffering issues or the sound quality issues, but many people are. And a lot of people are reporting that it just happens on this channel. It might be because I push the highest quality that streaming that YouTube allows, but that allows me to get the best picture and the best sound. Anyway, we're going to talk to him a little bit. Let's see why. My data rate that I push is usually between 9 and 11 megabytes per second, which is high. It's a 1080p high quality stream. I can turn it down a little bit, but I'd rather not. AZDCS Oversight Group, congratulations on hitting that 13-month milestone. Watch my fave channel while traveling. I'm excited to do my next trip and have high-speed internet with me anywhere I go. Not just cell phone, but Starlink. Weezer, I'm glad Amazon set you straight on the pricing. I'm sorry you just got crushed. It's a waste of really good hot chocolate. Mary, I don't know how your setup is. It's possible your TV uses Wi-Fi to connect and your computer uses wired internet. And it could be a weak Wi-Fi signal or just a crowded Wi-Fi space in your house. There's a lot of things it could be that cause that problem. Bertie, I am going to ask again about why some people cannot become members. What they need to do, what sort of account they need to have to enable them. It might be that you're set up as a business account, which I think is prevented from doing that. All right, here we go.
Quiet, please. Gady. All persons having any business before the Honorable Beverly County Justice in the Norfolk Superior Court in the Fulton County of Middleton. Your name, your intent shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Judge 22117, the Commonwealth versus Karen Reed. Can I have the counsel identify themselves for the record?
Thank you, Mr. Clerk. Good morning, Your Honor. Hank Brennan, on behalf of the Commonwealth, along with me is Attorney Adam Lally and also Attorney Laura McCall.
Good morning, Mr. Brennan. Good morning, Mr. Lally. Good morning, Ms. McCall.
Good morning, Your Honor. Elizabeth Little appearing on behalf of Defendant Karen Reed.
Good morning, Ms. Little.
And good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Unetti. Good morning, Ms. Reed. All right.
Also, thank you. Mr. Jackson appears to be in Zoom.
Okay, we can't see him though, Jim.
Yeah, we can't see you. Is that okay?
That's correct. All right. Good morning, Mr. Jackson. All right. We have several motions this morning. Let's start with motion for admission pro hoc vici that you filed. And Ms. Dinetti,
this is for the new
I know
lawyer.
these are freely granted, but I have a question about here. So you say good cause exists to grant this motion because Mr. Alessi has specialized skill and knowledge in representing defendants in matters of this nature. What do you mean?
Mr. Alessi is somebody with decades of experience in the courtroom, both on an appellate level and on a trial level. He has handled many criminal cases over his career. I have actually consulted with him on a criminal matter. I know of no better trial attorney in the country than Robert Alessi. There are aspects of our defense that would greatly benefit from his expertise. I'd rather not go into the specifics in terms of the division of labor on our team, but I'd ask the court to, take judicial notice that with his background, with his experience, he is going to add value to this team and protect my client's constitutional rights.
Okay, so he's not a criminal lawyer, but he's a lawyer who does some criminal work. I just don't understand what you mean by representing defendants in matters of this nature.
Right, of this criminal nature. He has represented criminal defendants throughout his career.
Okay. All right. Thank you. All right. So let's go on to the discovery motions. We'll start with the requested records of Mr. Reed. I'll hear you, Mr. Brennan.
Like the duct tape holding the microphone to the podium there. Way to go, Canton.
The Commonwealth has filed a Rule 17 motion to obtain phone records from William Reed for a 24-hour period. Secondly, the Commonwealth in that motion is looking for records regarding call logs for a 30-day period for William Reed. Although a different motion similarly, the Commonwealth has filed motions simply for the call log for 30 days for Janet Reed. The Commonwealth has a burden with two of these charges, one being second-degree murder, to show the element of knowledge. It is the government's burden to show that Miss Reed knew she struck John O'Keefe. Second-degree murder, as the court is aware, is a person committing an intentional act with a strong, plain likelihood of death. In a second-degree murder charge, there are a number of different theories that a Commonwealth can progress. It could be an intention to hit somebody, or it could be that somebody intentionally drove, struck somebody, left them behind, and didn't render aid knowing that there's a strong potential likelihood of death. When Miss Reed knew that she struck John O'Keefe is a critical issue in this case. Simply because the government has significant evidence outside of phone records to support and to convince that Miss Reed knew she hit John O'Keefe when she did, the government's entitled to their full value of their proof. The records for 30 days begin with that aspect of William Reed's records. Miss Reed calls her father and her mother a little after 1 o'clock on the night she struck and killed John O'Keefe. She calls both of them, and those calls were unanswered, according to the phone records. The inference that a 40-something-year-old woman is calling her parents at 1:30 in the morning after this tumultuous event, the inference is strong evidence that Miss Reed knew she had done something terrible.
Maybe it was
she
a butt
knew
dial.
she had struck John O'Keefe, and she knew that she had left him behind. The 30-day period is an attempt to protect the privacy rights of William and Janet Reed by not asking for the call, the text messages, not asking for SMS messages, not looking to forensically download the phone, just the call records, because I expect it will establish that there are no other calls in that 30-day period from Miss Reed to her parents at 1:30 in the morning.
But can't you get that from Ms. Reed's phone?
No. No. There were 2 search warrants on Miss Reed's phone.
I can't read them. The search warrant that was attached that I have isn't clear, so I'll need clear copies of those search warrants.
Those are provided by the defense. I can provide clear copies. The 2 search warrants on Miss Reed's phone are from a period of January 28, 6 p.m. to January 29th at 6 p.m.
Okay.
And the other one is January 28, 9:30 to January 29th, 5:30.
Okay.
And so they're not in Miss Reed's records. I am not looking to see any of the other numbers that the family called, friends, family, whatever their purpose is. I'm not looking to even see it. I want to see and demonstrate there's an absence of phone calls between Miss Reed and her parents the 30 days prior to when she drove into John O'Keefe. Now, it would help the defense. They want to expand that to 6 months or a year. I'm agreeable. Because if there was phone calls at 1:30 in the morning, I would not argue the inference that it was remarkable. That would be an unfair inference. But in the absence of any other calls, it is terribly remarkable that she is panic calling her parents at 1:30 in the morning.
This is the same argument they used in the burn
important.
pile case.
The type of injury John O'Keefe suffered that led to his death was a type of injury that was treatable. If he had received treatment within 1 to 2 hours, I expect that there are medical procedures that could have saved him. They could have produced a drill and drilled it into his brain to create bleeding so it wouldn't swell, or they could have cracked his cranium. Now, certainly he would have suffered significant impairment, but I expect the government is pursuing a witness, and my expectation on my research is a witness will say life-saving procedures within the first 2 hours would have saved or could have saved John O'Keefe.
Leeches as
and
well.
So if Miss
those are
Reed
some pretty
knew
serious
within the first 2
procedures.
hours that she hit him and that medical procedures could have saved his life, then this is relevant material to show her knowledge that something dramatic had happened. And that's why I want the 30 days. Only phone calls with her mother and father. Nothing else am I interested in. The second part is the 24-hour period with William Reed. The 24-hour phone records will show Mr. Reed's phone calls throughout that evening or that morning. And it's important because Mr. Reed had an opportunity to speak publicly, and he did so on Fox 25, which is the subject of another motion. And when he speaks to Fox 25, he gives what I see as an implied admission that his daughter told him that she had hit something. I think there's more to that story that will be explored at trial. The time of the phone calls to Miss Reed are important. They're reflected in her phone records in the morning that she speaks to her father while she's still in the back of a police car before she's brought to the hospital. In that discussion with Fox 25, the quote is, in your first discussions, my motion leaves off the yes in discussion, but it's in the first discussions, what did she tell you? Mr. Reed asserts that she tells him about this implied confession at the hospital, which is after the actual first conversation. And so it'll be important to be able to confront Mr. Reed, if necessary, with his own phone records. He can denounce or deny his daughter's phone records. He doesn't have to accept them as true. Also, in that first 24-hour period, it is important for the government to establish that Mr. Reed and only Mr. Reed controlled the phone. In the absence of a stipulation, this is proof that may be necessary at trial if Mr. Reed takes the position that other people had access to his phone. That first conversation where she admits that she struck something, i.e. Mr. O'Keefe, is critical to the government's case. And so we cannot rely just on Miss Reed's phone for a couple of reasons. Number one, phone records often show different communications. Sometimes calls or hang-ups don't register on a phone, and so they could be different. Secondly, I've learned that Miss Reed's phone was sent to a taint team, and the Commonwealth does not and should not know what, if anything, was redacted from Miss Reed's records. The idea of sending it to a taint team, I surmise, is that something was viewed that determined that it should go to a taint team, or perhaps the defense raised the issue. I don't have the benefit of the history. But what I do know is we cannot say that the records from Miss Reed are a full accounting of her records, and so that Mr. Reed's records stand separately from Miss Reed's records.
I don't like that argument.
Those are the two different types of records I am requesting from William Reed. I've been careful to make it limited. I'm not looking to see their physical phone. I'm not looking for a forensic download. After the first day of Mr. Reed's records, all I am looking for is call subscriber information and phone registers. I note the defense point of collateral information. I don't even want to see it. I just want to see if there's communication between Ms. Reed and her parents, so that if we present that inference, it is a sound inference, it is a fair inference, and it is a solid inference. And that's my argument regarding the phone records of Mr. Reed.
All right, who's arguing this for the defense?
Thank you, Your Honor.
Get him,
Your Honor,
Tiger.
the defense requests that the Commonwealth's Rule 17 motion seeking Ms. Reed's father's private cell phone information be denied. The Commonwealth is seeking 3 categories of information for Mr. Reed's cell phone: his private subscriber information, all call records, call detail records, SMS, MMS, and all data use records from January 29th and January 30th, 2022. And finally, all call detail records for an entire month-long period spanning December 30th, 2021 until January 30th, 2022. Your Honor, we are 3 years into this litigation, and the Commonwealth is now seeking to invade Mr. Reed's privacy under the guise that it's seeking communications between Mr. Reed and his daughter. But the Commonwealth already has a record of all of the communications between Mr. Reed and his daughter on January 29th, from not one, but 2 separate sources. The Commonwealth is in possession of Ms. Reed's cell phone. It's also in possession of Ms. Reed's Verizon records. The Commonwealth is asking this court to sanction this gross invasion of her father's privacy so that the Commonwealth can sift through Mr. Reed's electronic data for information that is already in the possession of the Commonwealth. Now, I know Mr. Brennan says, I'm not interested in seeing anything else. But the problem is, that's not what his motion says, right? He's asking for every single call, regardless of recipient, for a month-long period. William Reed has never been called by the Commonwealth to testify as a witness in this case.
So this is a new trial, right? So that doesn't prohibit the Commonwealth from calling him.
I understand, Your Honor.
Okay.
He wasn't present at 34 Fairview. He wasn't present at CF McCarthy's. And he wasn't present at the Waterfall on January 29th, 2022. And I would note that this court has repeatedly emphasized the importance of privacy concerns when it comes to an individual's cell phone, using that as a basis to deny the defendant's motions to obtain cell phone records from parties who were present that night.
Good for the goose, good for the gander.
The Commonwealth, again, is already in possession of Ms. Reed's cell phone. That has been reviewed by both a special master as well as the court, and the court is well aware that the Commonwealth has a full copy of those communications. And what's important is that those call logs confirm that Ms. Reed did not make any calls to her father on January 29th until after she discovered Mr. O'Keefe lying incapacitated on Brian Albert's front lawn. And I've attached a copy of those records to our motion. It's quite clear. There was one call to her father on the morning of January 29th. That was at 6:32 a.m. The Commonwealth has a copy of those records. It's in their possession. And as this court knows, Lampron explicitly requires that any Rule 17 motion must be accompanied by an affidavit containing a factual showing that all 4 elements of Lampron were met. Here, the Commonwealth has failed to meet its burden to meet even a single prong of that 4-part test. In regards to the burden that they have to establish that the records are evidentiary and relevant, the Commonwealth in its affidavit set forth no particularized facts whatsoever to suggest that relevant information will be found in Mr. Reed's Verizon records. The affidavit makes only vague reference to an interview Mr. Reed gave to Boston 25, but fails to explain why that interview suggests that relevant communications will be found on his phone records. And I would note, the Commonwealth's characterization of that interview is incorrect and incomplete. I submitted additional reporting from Boston 25, which is the news organization that published a portion of that interview. And it's quite clear that Mr. Reed goes on to state during that interview that what he's referring to when his daughter said, "I believe I hit something," was the Chevy Traverse, which the court knows. We have a video of her hitting a Chevy Traverse that morning.
Oops.
The Commonwealth is already in possession of Ms. Reed's communications from January 29th. Those were included in the Commonwealth's motion itself. And the Commonwealth has failed to explain why it believes additional relevant communications will be found in the call detail and text records. That was not included in the affidavit. The Commonwealth states they expect to substantively admit the phone records between Ms. Reed and her father to prove that the 6:32 a.m. call took place. But they can do that with the phone records that they already have. Just because they have records from Verizon, that doesn't establish who answered the phone. That's not something that they're going to get from Verizon. The Commonwealth is well aware of that fact because they have Ms. Reed's cell phone and her Verizon records, so they can confirm that there's only one call on the morning of January 29th. The Commonwealth has provided no factual basis whatsoever to suggest that there are relevant communications that will be found on January 30th, the day after this incident. And the Commonwealth also requests that Ms. Reed's phone records for the full month preceding January 29, 2022 is necessary to show that it would be unusual for Karen to have called her father. And the Commonwealth did a kind of funny thing, right? They suggested during their arguments that she called both parents in the middle of the night. That's not true. There was only one call to her father on January 29th, the morning of. It was at 6:32 a.m. So the frequency at which Ms. Reed calls her father's cell phone in the middle of the night has no relevance whatsoever. As to the second element of Lampron, here the Commonwealth's affidavit is facially deficient. It doesn't even reference this element or set forth any facts supporting that it's shown that the Commonwealth's records are not otherwise procurable reasonably in advance of trial. And the reason Mr. Brennan cannot in good faith make that statement under oath is because the Commonwealth is already in possession of these communications from two separate sources.
She has a good argument.
Element 3 of
She should be
Lampron was
strong with
also
this.
not addressed in the Commonwealth's affidavit. It's facially deficient. The Commonwealth has failed to show that it cannot properly prepare for trial without the production of this evidence, and that the failure to obtain the evidence would unreasonably delay trial. Again, that's because the Commonwealth is already in possession of the evidence that they're requesting. Finally, the Commonwealth has also failed to show that this request is made in good faith and is not a fishing expedition. In its affidavit, the Commonwealth briefly addresses the fourth element of Lampron, but writes only, quote, "The Commonwealth's motion is not a fishing expedition, as it is evidence from the defendant's phone records that phone calls between defendant and Mr. Reed were made sometime after defendant struck the victim and before the victim was found." Your Honor, that statement is provably false. Ms. Reed's phone records established conclusively that she did not call her father on January 29th until 6:32 a.m., after she found her boyfriend incapacitated on Brian Albert's front lawn. Therefore, the requested records should not be turned over to the Commonwealth. This is a broad request to review a month's worth of Mr. Reed's private cell phone information and all of his data usage information from January 29th and January 30th. This is a fishing expedition, plain and simple. The Commonwealth isn't asking for the records it already has. It doesn't need a third copy of them. What it's looking to do is sift through Mr. Reed's personal cell phone information on January 29th to see if it can find data usage information, location information, text messages with other individuals, and that is a completely inappropriate use of Rule 17. This unsupported request is overbroad and must be denied. Thank you.
All right, thank you. Did you want to respond in any way, Mr. Brennan, or move on?
Very briefly.
Okay.
We're going to be in Sarah Boone's sentencing that
In
day.
between the multiple accusations of bad faith, what the attorney says that is most telling is they don't know who answered the phone. That's a harbinger to trial. The prosecution doesn't know who answered the phone when Karen Reed called her parents or her mother's phone at 1:43 a.m. No, the Commonwealth doesn't. And so we have to prepare that when Mr. Reed takes the stand, we have phone records demonstrating all of his phone calls and that he had control of that phone So there can't be a suggestion somebody else was handling the phone. Or, on the other hand, if the position is going to be that Janet Reed answered the phone, the father's phone, or that William Reed answered the mother's phone, then we'll call both witnesses at trial and we'll sort it out. But it is that very nature of suggesting confusion or uncertainty that the government is obligated to try to prevent at trial. And we're being diligent, we're being studious, and we're going to be prepared. And these records will help us do that.
The record won't tell you who answered what.
That is the exact point and reason why we need these records. Thank you.
All right, did you want to respond at all, Ms. Little?
Well, I think the Commonwealth actually brought up the issue of, it tried to basically say, I need the Verizon records because Karen's phone records don't establish that Mr. Reed answered the phone. But all I'm saying is that neither do the Verizon records. So there is no additional information that the Commonwealth is going to obtain by digging through Mr. Reed's private cell phone information.
Okay. All right, so we sort of overlapped a little bit with Mrs. Reed, Janet Reed's records. Do you want to be heard further on that, Mr. Brennan?
No, I believe the court understands my argument unless the court has any questions for me.
I don't, but thank you. Ms. Little, is there anything specific to Mrs. Reed that you want to address?
Yes.
Yes, Your Honor. Again, I just emphasize that the affidavit in support of their request for Ms. Reed's phone records is plainly insufficient. They haven't addressed numerous elements of land prime. That alone is a basis to deny the request, and it's not permissive. It's mandatory that the court deny the request. Land prime is very clear. If you don't meet a factual showing in the affidavit in support of your Rule 17 motion, then the motion must be denied. 3 of the elements were not even addressed in that motion. So on that basis, we request that the court deny the motion.
Okay.
Good argument.
Thank you.
This has appeal
So
written
we
all
will
over it.
move along
If
now.
the
Both of those
judge,
are under advisement. We'll
Yeah, she's
move
not gonna
along
rule
now
today.
to paper number 405, Commonwealth's renewed motion for all audio recordings, notes, emails, text messages, voicemails, and the possession of Gretchen Voss and/or Metro Corp. I do have an opposition that I received this morning, and an affidavit from Robert Birch, attorney Robert Birch, who I think is present in court. So, Jim, did he file an appearance too?
He has previously filed.
And we'll use that in this case as well. All right, so Ms. Little, you did not intend to argue that, right?
No, Your Honor.
Okay, so Mr. Brennan, I'll hear you, and then Mr. Birch, I'll hear you.
The Commonwealth has filed a motion to reconsider in part, and in addition, there is a request for information that was not requested before by the Commonwealth. Your Honor made a ruling in the past to turn over portions of the materials, and in that ruling, it invited the Commonwealth after review to renew or reconsider the motion or the extent of the motion. I've had an opportunity to listen to the hearing. I've had an opportunity to review all of the pleadings relative to the Boston Magazine and Ms. Voss information. And I've had the benefit of observing numerous other statements that have been made by Ms. Reed publicly. And I've been able to contrast and compare the statements made to Ms. Voss as well as the statements made to a number of other media organizations, including Dateline, 2020, Vanity Fair. And after a review of all those materials, it is clear that there is significant materials that were not turned over to the Commonwealth that are relevant material and substantive evidence in this case. In listening to the past hearing, the position of Boston Magazine was that almost everything was entirely on record and that there were a few interchanges by the attorneys. Not only did I have an opportunity to read the Boston Magazine article and listen to the interviews, but I had them transcribed, have a copy for the court if the court pleases.
Okay, that would be helpful.
And there were 2 different interviews that were turned over. One was represented at the last hearing, that it was 4 hours long. The Commonwealth received 3 hours and 19 minutes. It's missing not a little bit, a significant portion of that hearing, 40 minutes. The second interview was represented in the audio recording of court that I listened to as a 2-hour interview. The Commonwealth received merely 19 minutes. So the majority of that interview was not provided. And so there wasn't just a few redactions, they were significant. In addition, which is notable, and you can glean this from the transcripts, is that there wasn't just a few interruptions. Mr. Yannetti is noted on the transcript 37 times, Attorney Little 33 times, and Attorney Jackson 33 times. And so there are significant interruptions and redactions in both recordings. These redactions in the recordings are important. One thing that stands out when you actually listen to the interviews and you look at the transcripts is that many times during the attorney's interruptions, there's a redaction, and then when the conversation resumes, there is a change, sometimes subtle, sometimes not so. There is a change in the statement by Ms. Reed. And so it is clear that there is an inference that in those redacted portions, there is conversation or consultation or discussion happening that changes the direction and sometimes the content of Ms. Reed's statements. That bears directly on the credibility of the witness. Because be mindful, all of her statements are admissible. All of them. They're all substantive evidence. There's no hearsay. There's no limitation. They are statements of the defendant. They're material and relevant, and the Commonwealth is free to use any and all of them at their discretion. And so it's not only what she says in the interview, it is what is missing in the redactions. Now, certainly, there may be discussions in those redactions that involve her attorneys and Ms. Voss. But none of that is protected. None of that is protected. A defendant enjoys many privileges, but when an accused decides to cast aside their privileges, they don't get to add their own layer of protection. There's absolutely no basis in our jurisprudence for a defendant to be able to do that. They enjoy a Fifth Amendment privilege as they should. A defendant is presumed innocent. But when they cast it aside, it's at their own peril. They have an attorney-client privilege. But when they obviate the attorney-client privilege by speaking in front of a third party that's not part of the prosecution team, that privilege no longer exists. It dies. And there is no reporter privilege in Massachusetts. And so what has happened in this interview is that we have 3 attorneys, a defendant, and a reporter having a free reign of interview, and then later deciding what parts of the interview they want the public to hear, what parts of the interview they want the Commonwealth to have possession of. They don't have, respectfully, that choice or that power or that discretion. They can contract with each other, have their own side agreements and what they want about on and off the record, but it doesn't bind the Commonwealth. It never has, it never will. We don't agree to it. And so what we have is many instances and examples where those redacted portions are critical to understanding why the story at times changes after the redactions. And so I think of it this way. If Ms. Voss was called to testify by the Commonwealth at trial, and we have her on the stand, and I was to say to her, I've received your recordings and your redactions, and I've read your article, Ms. Voss. I want to ask you about the conversation after Ms. Reed talks about sipping drinks at the waterfall, and it's redacted. I want you to tell me what she said. There could be no objection for the defense that there's a private agreement. There could be no objection from the defense that somehow it's privileged. She would have to answer the question, this is what Karen Reed told me. So to suggest that pre-trial, somehow they can have this protection that doesn't exist in reality in the law, to protect statements that the defendant or their attorneys made that they don't want the Commonwealth to learn about, is just wishful thinking. That's all it is. And, you know, I'm not oblivious to the fact that there are a number of statements that are made that are redacted to Ms. Voss where the defense attorneys are present in the room. There is no attorney-client privilege at that point. There's none. Arguably, all 3 of the attorneys are witnesses as well. Now, Commonwealth is not heavy-handed. The Commonwealth does not want to disrupt the defense team. The Commonwealth does not want to delay this trial. The Commonwealth does not want to put an attorney in an uncomfortable position. But they're all witnesses to a substantive statement, many of them admissions of guilt, contradictions, all of them, in the most respectful way to pursue those, the strongest way, the fairest way to pursue those, with moderation, is to get them from Emily Voss in the interview that exists. Now, in the pleadings, I received the response this morning. I didn't get to read the entire thing. I have no objection to it. But I did listen to the hearing. And it strikes me that the argument of the newspaper company was primarily based on two propositions. Number one, Commonwealth versus Doe, promulgation, those cases, when you read them, deal with confidential informants. Not confidential information or what someone wants to be confidential. It's not even confidential. She said it, she said it. There's a difference, and Your Honor pointed out in that hearing. Could you give me a case that talks about confidential information as it does confidential informants? And respectfully, there was no case to be produced, because there is none. The cases are dissimilar, because they deal with trying to get to a confidential source that may expose a source that never even may not be used at trial anyways, because it's based on hearsay or there's no factual basis for it. This is not a confidential informant. The defense chose a strategy, a very strategic strategy, to sell their story and disseminate to the public, potential jury pool, in a way they thought best fit their needs. And they've done this continually. And although an attorney cannot produce evidence to the public or encourage it, it violates the rules of professional responsibility. They cannot have a statement that is meant to reach the potential jury. A defendant can. The Commonwealth does not resent that Ms. Reed has made statements to all of these different outlets. She's entitled to. She's presumed innocent. She can make all the statements she wants. But when she does, there is a consequence for that. And they now bear the consequence of these statements that have been made. And so, since it is not a confidential informant, it's a very public, identified person, it's Ms. Reed herself, the argument of Doe and promulgation has no merit. I know Your Honor was troubled by the affidavit of Ms. Voss and that she was afraid for her safety. And from a personal level, I empathize. In this case, firsthand, I've never seen anything like this, where witnesses have to fear walking out of their car. It's repugnant. It undermines the fabric of the judicial system. But Ms. Voss isn't alone, and I have empathy for her. Almost every witness, civilian witness for the Commonwealth, has sustained similar or far more egregious abuses. It is awful to think the level of harassment and intimidation that someone must suffer because they're simply a witness in a case. And my empathy is to Ms. Voss, but to every other witness in this case, she is in no different position. It does not impede the progress of the Commonwealth. It does not impede the fact-finding mission. It's unfair. It shouldn't happen. Something should happen as a result, but it has no bearing on the analysis in this case. It just doesn't. And so there is a ton of conversation that has been redacted arbitrarily by parties that want to use what's in their best interest, but cover up what doesn't help them. The Commonwealth is entitled to it, and we're seeking it and we want it. We want all the redactions in the first and second interview. Over 75% of the second interview is redacted. We want the notes from the third interview. Ms. Voss is a witness. She wasn't at the scene. She didn't see Ms. Reed drive into John O'Keefe and leave him in the snow, but she's a witness to substantive statements, her statements, admissions, confessions. And those notes evidence the statements of Ms. Reed. They're clearly discoverable. And the email or text message and phone call, again, statements of the defendant. Ms. Voss, reporter or not, is a witness in this case to some of the most crucial damning evidence in this case. We're entitled to it. We take no exception for it. Thank you.
All right, thank you. Mr. Birch.
Thank you, Your Honor. Robert Birch for Metro Court and Gretchen Voss. I've been here before, Your Honor, on a remarkably similar motion. And Your Honor at that time made a Solomonic decision and said that 2 audio tapes minus attorney dialogue and off-the-record comments would have to be produced. And the one-on-one off-the-record interview between Gretchen Voss and Ms. Reed did not have to be produced. And the Commonwealth has simply made no persuasive showing as to why the decision should be any different now. The Commonwealth makes much of the fact that there are heavy redactions on the shorter of the 2 taped interviews. They refer to it as a 2-hour interview. Actually, it was a 1-hour interview according to the affidavit of Gretchen Voss, which had been submitted with our original opposition to the first motion. So it wasn't quite as lopsided as counsel is intimating. But in any event, the reason for the redactions is that the Commonwealth made a point in its original motion that it was not seeking anything but the defendant's statements, that it did not want colloquy of attorneys. It did not seek what the attorneys were saying. And it said that over and over in its original motion. Now it's suddenly changing the rules and says, oops, we've decided we want those after all.
Didn't I leave that open for them, though? Didn't I leave that open for them to come back, even at the first trial, to come back and request it upon review of the first release?
I'm sorry, I didn't quite.
I left that open for the Commonwealth to come back the first time even, right? The first trial. And we have here now a new trial. We have different attorneys presumed with today's motion on both sides. So why are we focusing on what they requested first and what's different than now?
Well, Your Honor, I think the burden on the press is, it's still the prosecution seeking information from the press. They got a certain amount of it. They're now asking for more of it. And the question is, why do they need that more? They had made a determination at one time that in order to be fully prepared for trial, they only needed a certain amount. And they only did not need attorney's colloquy. And now they're saying the attorney's colloquy is central to what they need. They can't have it both ways.
Okay.
They want the full recording. Everything.
The change of subject from one before and after a colloquy, he says, bears on the credibility of the defendant. But if the defendant contradicts herself in the course of an interview with Gretchen Voss, I fail to see how that has the impact of serving as grist for impeachment at trial. And one has to wonder whether this motion is really an effort to keep Ms. Voss off the stand and off from reporting, because she, in fact, has suffered, as Your Honor noted at the earlier hearing, from harassment. And Your Honor noted in your order that the disclosure of the material sought would require her to divulge information that will hinder her ability as a journalist to assure sources that she will keep certain information confidential. That's what she averred. And her affidavit also details the harassment she's endured since the publication of her article, and her fear that if compelled to turn over the requested material, in particular the handwritten notes of the off-the-record interview, she'll be exposing herself to further harassment and endangering the safety of herself and her family. And Your Honor wrote, given the extraordinary public attention and scrutiny given to this case, and her fears for her own safety and that of her family are no doubt warranted, and in light of the concerns set forth in her affidavit, the court concludes that the asserted damage to the free flow of information is more than speculative or theoretical. You said it was a close call, but given making the division, what I call the Solomonic division of providing some and limiting others, seemed to make sense. So what are they seeking now that they didn't have before? Well, in addition to seeking the redacted portions of the interviews, which Metro Corp and its counsel undertook at time and expense to redact them to accord with what the subpoena as approved, what the subpoena as issued had asked for. They're asking now for the handwritten notes of Ms. Voss of a one-on-one off-the-record interview that she had with no attorneys present. Those are handwritten notes. There's no audio tape. They are partial notes. They are they're phrases. They're not complete thoughts. They're more jog memory sorts of telegraphic mentions. So it seems likely that if required to turn over these notes, which essentially represent the work product of the journalist and her personality as expressed in her, what she takes from the interview, if forced to produce that, it's very likely the next step is that the Commonwealth is going to want to depose her or call her a trial in order to explain those notes and interpret them. And that's going to take us down yet one more rabbit hole in this case. That this already had so many. It would also have the effect, maybe the calculated effect, of preventing Ms. Voss from covering the trial, because if she is called to witness, she is not permitted to sit in the courtroom for the proceedings.
So she did attend the last trial, right?
She did, because she was not on the witness list.
Right, on a daily basis?
I believe so, yes.
Okay.
Every day? Yes.
Okay.
Every
thank
day.
you. And that was Ms. Voss who just responded to you?
I'm sorry.
That was Ms. Voss who just responded to you, yes, correct?
Yes.
Okay, thank you.
That's significant.
And finally, the Commonwealth asks for...
That's retribution to keep a reporter
for the
out.
first time for texts between Ms. Reed and Ms. Voss. And we do have texts. They are... the manner in which they get forwarded from an iPhone is that they come out without the name of the speaker. You can sort of guess at the name of the speaker, but you don't see the name of the speaker. You also don't see the date and time of the communication. I'd ask that we're willing to turn those over. They were not off the record. But I ask that we be able to turn them over in that form, which is the form we have them in, rather than go to whatever expense and trouble to replicate a different format.
Okay.
And that's all I have.
Okay, so
All right.
a strong argument for...
Mr. Brennan, I'll give you a chance to respond, but I do have a question for you based on Mr. Birch's opposition. If you've got the opposition with you, Mr. Brennan?
I have a copy, Your Honor.
Okay. So
They
what I'm
want- they
going
want
to
the
ask you
reporter's
to
notes.
respond to is on page 5,
That's going to make her take the stand to explain them, because they're
first
not...
full
they have to be complete.
paragraph. The paragraph begins that this litigation, but the sentence is, In other words, the Commonwealth says it needs more audio because the redacted audio provided thus far either contains no damaging admissions by Reed or reveals that she was not entirely forthright in her unsworn press interviews with Voss. What do you say about that? You touched upon it when you started your argument today about inconsistencies. What's your argument to that specific?
Having received this morning, having not had an opportunity to read it, could I just have one moment to read it in context?
Sure.
Thank you.
We have a lot of people in the audience that have been, or the gallery that have been following this case for a while. Obviously, we've got family members on both sides. I do see the glare there. We've got Turtle Boy is there. You've got Miss Voss, the reporter, who's there as well. A lot of notable people who've been quite present. For instance, you've got John's brother right there. Boom. Yeah, it's like
This posits two separate ideas, the way I interpret it. The first is the Commonwealth says it needs more audio because the redacted audio provided thus far either contains no damaging omissions by Reed. The audio provided this far contains many damaging admissions to Reed. In her first interview with Gretchen Voss, she talks about when she dropped John off and where she dropped him off. It's noticeable in many, many interviews, the story changes.
He's in the white suit jacket, right?
At one point, she has them going to the side door of the house. In fact, in 3 of the interviews, he's going to the side door of the house. In a further interview, she says he went to the front door of the house. It's not subtle. There's a reason. The stories and the versions given by Ms. Reed evolve in time. Coincidentally, they evolve sometimes with the production of Discovery. And so I am not suggesting for a second that there are no damaging statements by Ms. Reed. In fact, there are confessions, there are admissions, and there are contradictions based on later statements given. And so all I can simply say is that is not the Commonwealth's position. That is stated wrongly. Also, or it reveals that she was not entirely forthright in her unsworn press interviews with Voss. Well, we're entitled to take her statements with Ms. Voss and compare them to all the other statements she made. 2020, Vanity Fair, Dateline, and others. And so the question isn't whether her statement to Voss or Ms. Voss is accurate. It is in comparison to other statements. Is it accurate? And we know that it's not. There are many instances where she has given different statements between versions. Also internally, in Ms. Voss's interview, as I mentioned, there are statements, redaction, a return, and a different statement. For example, she was only sipping at the waterfall, which would suggest further drinking. And then after a redaction and interruption, she's sipping water at the waterfall, as incredulous as that may be. And so clearly something happened during that redaction that changed the admission to drinking alcohol, which is part of this case, to something of water. And so I think that the claim in this motion really has no relevance to the analysis. It's not on point. The reason I said there was a 2-hour interview, and I'll accept that I'm wrong, is when I listened to the FTR tape, counsel respectfully said it was a 2-hour interview. And that's where I got my information from, not Ms. Voss's affidavit. So it may have been a 1-hour interview, which still leaves us with 1/3 of the interview, 2/3 redacted. That is significant. The Commonwealth comes back, we're entitled to come back when we want, if we have a good faith basis and if the court invites us. We come back now after I've had a chance to actually listen to the 4 hours of interview, or you add them up, 3 hours and 40 minutes of interview. I've studied them, I've listened to them many times. I've ordered transcripts, I've perused the transcripts, I've compared the two. I've compared them to all the other statements. So time has now made these much more relevant than they maybe initially thought. I can't speak for the Commonwealth at that point. We're entitled to the full force of our proof. We don't have to just take some. We don't have to take a fraction. Just because it's inconvenient or uncomfortable for parties, the government is entitled to the full force of their proof. in representing the people of this Commonwealth, I am pursuing the full force of our proof in every aspect because we're entitled to it. It is notable in the FTR hearing that counsel for Ms. Voss and for the publication said that the third interview they discussed, and the parties, meaning the defense attorneys, the defendant, the defense attorney, the defendant, and Ms. Voss could decide to use that material. It wasn't that it was precluded or no one could ever see it. It's only if it helped them. And so he said that they agreed that if they wanted to, they could use that material. They just decided not to. Because they decided not to use incriminating information in their story doesn't give them the power to decide who does and when they do. So we're entitled to the full force of our proof, and we're going to pursue it. We're entitled to all of these records, all this information. There is no legal argument against it. None.
None?
All right. Thank you. So I know, Ms. Little, I asked if you wanted to say anything. I just give you that opportunity. Was there anything you wanted to add?
No, Your Honor.
Okay. All right, so that is taken under advisement. And now we have 3 more motions. I understand Mr. Albano is here, who will be filing an appearance on all 3 or arguing all 3. But so, Mr. Albano, you can come forward, sir. And Mr. Brennan, do you want to argue each one of these individually? It appears I did get an opposition this morning that goes to service, which pertains to all 3. But do you have different arguments, a little bit different on each?
I do.
Okay, so Mr. Albano, do you want to be heard after each argument, or do you want to just be heard at the end of the 3? There are 3 motions. FXT TV, Boston 25, WCVB TV, Hearst Television Incorporated and ABC, and NBC 10, Boston. Okay, thank you. And again, on these, Ms. Little, you don't expect to argue?
No, Your Honor.
Okay. If you do change your mind, just stand up and let me know. No, that's fine. Okay. All right, I will hear you. Why don't we start with the FXT TV, Boston 25. It's paper number 400.
As has been discussed, Fox 25 and its employees conducted an interview of William and Janet Reed. I've quoted on subsection 5 some of the language from that interview. And during my quote, it says, during your first discussion with Karen. It should say, during your first discussions with Karen. There's an S left off. Nevertheless, during your first discussions with Karen, did you believe she may have hit John?
Did she believe?
Yes.
Okay, I thought you said, did you believe?
Then I misspoke. My apologies. Did she believe she may have hit John? William Reed responded, no, she felt she struck something. She said, Dad, I think I struck something. I said, what do you mean, right? This was in the hospital, right? She says, I remember, all right, backing up and hitting something. I've had the benefit of at least looking at the phone records that are available for Karen Reed and seeing there was a phone conversation that morning to William Reed's phone. That phone conversation is before Karen Reed is admitted to the hospital. And so it is, by inference, in the back of a police car at the scene. Now, there's some ambiguity during your first discussions. The operative word, as I see it, is first. It is a particularly remarkable statement to make that in the throes of realizing the great tragedy that's unfolding with John O'Keefe lying in the snow dying, that the comment of thinking that they hit, supposedly now, another car in a driveway hours earlier would be the topic of conversation at that point. There is not a fair inference that that would be the subject matter. It is not a fair conclusion that a person would be so fixated on a mere nudging of another car that caused no damage hours earlier when we're dealing with the potential loss of life. And so I think it is reasonable to infer that that was actually not the complete statement. The conversation lasted on that morning for over a minute, and there was certainly conversations after. And so the defendant's father has, as he's entitled to, utilized media to try to sell a story to help his daughter. And during that airing, it is clear and obvious that not the entire conversation with William Reed has been provided. During these stories, oftentimes there is summaries to progress the episode much quicker. And so all of his statements, which may not be a lot, but all of his statements to that employee of Fox 25 who did the interview should be discoverable so that this statement can be put into context, similar to the doctrine of completeness. We should know what the entirety of the conversation, the interview was, so that we can assess this statement and draw the proper inferences from it. It is expected that William Reed very likely will be a witness at trial. He will be asked about this conversation. He may be asked about what else he had said. It will be impossible at trial then to try to produce the other statements that he has made to this network or this employee. And so the Commonwealth, or anybody who would be questioning him, would be just simply left to the whim of his answer. And I'm not satisfied to do that. I do not think there is any protection. He is not a defendant. There is no privilege. And so there is no reason to protect this information so that it can fairly be brought into context so that when he is cross-examined, if there is evidence of impeachment or corroboration, that both sides are aware and know of the substance of that material. And that is the reason we request the pleading in number 400 for the Fox 25 footage that was not aired.
Okay. Have you had a chance to read Mr. Albano's opposition this morning? It's not very long.
I haven't, but I can say Mr. Albano kindly called me. He outlined the issues in an email. He made this a much more streamlined and agreeable process. And so I credit him with his effort. I don't need to read his response. I'll appreciate what he says.
Okay.
My short interaction with him, his total candor, I have no hesitation what he says in his representations. I might disagree, but I don't need to read his pleading.
Okay.
There are two, NBC and ABC. Your Honor would allow me to start with NBC because I think we can streamline that. NBC 10 has agreed to give promo materials in their possession. I've not only spoke to Mr. Albano, but I've spoke to the attorney for the subsidiaries that we also had subpoenaed. And they told me that as subsidiaries, they do not have possession of the materials of the parent company. And I received letters from the attorneys stating as much. So as it pertains to NBC 10, the position is
they're
that
chasing everybody that did interviews with the family.
one of the subsidiaries is going to send us promotional materials. And as far as service on the parent company, I don't think the Commonwealth succeeded, despite the fact that we made numerous efforts in hand, mail, UPS to a number of subsidiaries. I don't think we satisfied, so I do not want to ask the court to progress that.
Okay. Do you have a timeline on when you'll get this material?
The promotional materials?
Yes.
They said they were putting them together. I did not ask for a timeline.
Okay.
The promotional materials are a very small fragment. It's I've only seen one clip aired. I don't know what else they have, but it should not take them long.
Okay. I don't have a paper number. Jim, do you have the paper number on NBC 10? Here, just, you know what, Jimmy, you can give it to me after. I don't have that paper number or the other one. All right, so do you want to...
427, Your Honor.
What do 427?
427, yes.
The Commonwealth incorporating the media into
All right,
this next
so do you want to
trial,
move on to CVB TV?
where
Yes.
I guess you could
Okay.
say the defense incorporated them during the first trial. NBC 10 Boston or Philly?
WCVB TV has been served, and they've notified that they're not in possession of the materials, have no control over the parent company, and they are not part of the company. And so I no longer am asking WCVB-TV to produce these materials. Instead, in the alternative, we have subpoenaed the registered agent in Massachusetts, the registered agent for the parent company. They have been properly served. If we look at the Secretary of Commonwealth of Massachusetts Business Entity Summary website, not only do they have a principal place of business in New York, but they also have, as a registered agent, a local address, 84 State Street. So our position relative to the ABC materials is that ABC has been properly served locally. Unlike NBC, that did not have a local registered agent that we could find, or perhaps does not have one, ABC does. ABC does business in Massachusetts. In fact, these interviews with Ms. Reed may have taken place in Massachusetts. I don't know. But they have roots in Massachusetts in that they do business here. They have a local registered agent. And the reason to have a registered agent is to accept service, provide notice in case there's objections, and to provide materials. It is done routinely in civil cases when a registered agent is notified. They are then obligated to get materials even if the REM exists in a different place. Their position is that the REM exists in New York. That is irrelevant to the assessment in this case. To suggest that somehow the physical property being another jurisdiction is not in the control or purview of the local registered agent would just be enacting a shell game where local or companies could pick jurisdictions they find most favorable, do business in outside jurisdictions, and avoid the consequences of that. That, I don't believe, is how the law is set up. As a registered agent, they are the same as the company. They just have a local contact to accept all types of service, communications, and responsibility. And so our position on ABC as far as service is concerned is they've been served through the registered agent, and therefore whatever materials exist, regardless if they're in Massachusetts or in New York, they are required to obtain them and they're required to produce them.
Okay, so Mr. Albano disagrees with you, and on the third page of his memo under paragraph 5, so I will give you the opportunity to read that.
Okay.
Under that fifth paragraph. Do you want to address the substance of your motion regarding ABC?
I do. Much like other recorded statements, we see from the Nightline in the 2020 interviews, there are a number of public statements that Ms. Reed has made to a national audience that don't reconcile with other statements she has made at other times. I've given you the example of not knowing which door she supposedly saw John Keefe go into. There is differences in her stories and versions about where she was that night after she left the O'Keefe house. There is a number of examples where the different versions given contradict each other. And so although they're all substantive statements, they're all admissions and confessions, they still have a value in the fact that they contradict each other. And so the episode that is aired on 2020 and Nightline, you hear oftentimes the author of the story, not even the interviewer, the author saying, and we spoke to the person, and then this is what happened, and then they go to a clip of an actual interview. The summary by the author is not admissible. It can't be used substantively. It can't be used to impeach Ms. Reed should she testify. It is hearsay. It's inadmissible. And so these summaries have a genesis somewhere. There's a reason why the reporter is asking certain questions, or more importantly, the author is summarizing testimony, oftentimes inconsistent with other versions. And so that means that there is footage from which the author has gleaned this information. There's either footage or there's a conversation with Ms. Reed. And so those are statements, not unsimilar to or dissimilar to Ms. Voss interviewing here. Those are statements of a defendant which are substantive evidence for their full value. And so that footage we're entitled to see. There's nothing that should protect it. We should have the opportunity to review all of the statements and also put the ones in context that were broadcast to the nation. And that's the substance of why we want it. I'll have to take a moment to look at the response.
Okay. Mr. Albano, we'll give him a couple of minutes just to read it.
So they're hearsay. They're not admissible in court, but they want them to dig around and see what they can find. It does come across a little bit that the Commonwealth is a little upset that that Karen was able to get a message out so widely, even during the trial. And now it seems like this is punishment.
Paragraph 5, it's on page 3. The pages aren't numbered.
Seems like this is punishment. It could definitely
Actually,
hurt
you should start
the
at 4.
reporters
Or
if they
why don't
all
we
get
read the whole
subpoenaed.
thing,
All
Mr.
the
Brown? Why don't you
interviewers
have a
get
seat and read
subpoenaed.
it?
They can't do anything on this story during the trial. They practically can't show up at work if they get called as witnesses. It's not the Vickers. It's just arresting. The glare is the top right corner there. He's in back. Sort of the short white hair, goatee, turned to his right now. That's the glare. Trying to remember who the girl is next to him. There's fixed her hair. These are all familiar faces I've seen, but I'm bad with names. Yeah, it becomes a gag order. Now we're doing a fit check. What was that? Meredith? That's Meredith, his girlfriend. Nice close-up on the attorneys, the consult. Getting some quick B-roll shots. You ready, sir?
May I?
Sure.
Thank you. Your Honor, our position is we disagree with that proposition. We are not trying to subpoena another state witness. We're trying to subpoena materials from a company, and although the company has a principal place of business in another state, by having a registered agent, we believe that gives us jurisdiction. I can understand the company would like to remove this to New York. There is a reporter's privilege in New York that is profound. It is not so in Massachusetts. In Massachusetts, there is none. And so I see why it is the company's preference for us to go to New York, to use New York law, but I don't believe that's the case. I believe as a registered agent that we have an entitlement to subpoena them here, and we follow Massachusetts law. There are a couple of cases in the memorandum that I'm not aware of. I think it would be prudent for me to research and shepherdize, and because I think I have an obligation to do that. I would ask you to allow me to have a day to provide a brief supplement. It's not to re-argue the case or the merits of the case, but if there is adverse case law, I want to recognize and acknowledge it. But not.
I'll give you that opportunity, but I will hear from Mr. Albano today since he's here.
Of course. But our position is, although they would like us to go to New York, we can subpoena in Massachusetts to the registered agent, and that entitles us to the material. So that's the way we've done it.
Okay.
Thank you.
All right, Mr. Albano.
Oftentimes, if you do business in the state, you have to comply with their laws to some extent.
The two cases I cited, just to be clear, they address the Uniform Act, which Your Honor dealt with last year. They don't address the specific issue the Commonwealth has raised, which is, okay, you have a registered agent, we serve the registered agent, does that trump the Uniform Act? I have to say, I did not find a case that dealt directly or even indirectly with that. But here's why I believe the service issue does not override the Uniform Act. First of all, we're dealing with a statute. Statute talks about a witness in another state. There's no dispute that ABC is a foreign corporation with a principal place of business in New York. Now, the analogous areas I thought of was, okay, let's say someone wanted to sue ABC in this court. Yes, they could serve them through their registered agent, but that wouldn't change the domicile or citizenship of ABC if there were a diverse plaintiff and a diverse defendant, it would still be removable. It doesn't make them residents of Massachusetts, or for example, subject to taxes in Massachusetts. It's simply a way to make service of process, but the plain language of the Uniform Act and the policy underlying it is not overridden by service. The two cases that I did cite, one is the grand jury case out of I think it started in Rhode Island, SJC case, and that just generally explains how this Uniform Act works. You go to the Superior Court here, you get an order, you travel to New York, and New York decides whether the subpoena will issue. The second case, which I think was in re contempt or something like that, was the SJC saying, by the way, the receiving court, and in that case, Massachusetts was the receiving court, we don't just rubber stamp these if there's a privilege issue in our state. And so that's what tells us that if this court issues an order under the Uniform Act, Commonwealth travels to New York, the New York court then decides, does it enforce it, or does the privilege that exists in New York, is that privilege dispositive? And that's what we say is the right answer here, that yeah, they have a point, they can make service, but it doesn't override the statutory requirements of the Uniform Act. And as to the other, I think things are pretty much under control with the other motions. WBTS, which is NBC 10, has previously published those promotion ads for the show, and they say, well, no, they've already been out, fine, we'll get you copies, and that's what I've been told by the client as well. WFXT, which unlike ABC is here, does have some raw footage. The station's position is that if Your Honor decides under the Rule 17
yo-yo cam going here
standard that yes, this footage is relevant enough to come within the Rule 17 scope, then WFXT will produce that information. I do expect it will already be published before, so the unpublished I do expect won't be unpublished anymore, so they'll probably be in a position where they're simply turning over published information, not unpublished information. But I do think that, so I think WBTS and WFXT are effectively resolved.
Okay. Do you want to respond, Mr. Ryan? Thank you, Mr. Albano.
Yes, he does.
I'd just like to give one example that I'm sure you've thought of, and we see it often in tort law. If U-Haul is a foreign company, I don't know where it's located, but if the principal place of business is in Texas, and there's an accident here in Massachusetts, and I'm requesting as part of my litigation corporate materials, I do not have to follow the Uniform Act to go to Texas or litigate in Texas under Texas law. Because the company operates also in Massachusetts, as does ABC. I can sue in Massachusetts, and that company, this registered agent, is obligated to get those materials for me. Otherwise, a company could simply hide in whatever state is most beneficial to them, make it impossible to litigate or obtain materials.
That defeats the Uniform Act
Throughout the entire process.
That's why the Uniform Act exists.
We have jurisdiction here because they operate here, because they have a registered agent here. It does not matter where their corporate or their headquarters is. Thank you.
All right, any follow-up, Mr. Albano? Sure.
Okay, I'm getting whiplash.
My first point is that we're dealing with a statute here, and the statute says this is how it works when you have an out-of-state witness in a criminal case. So that's different than civil discovery. The second thing I'd say is ABC has a registered agent here, but WCPP is owned and operated by Hearst Corporation. Hearst Corporation is totally separate from ABC. That's why neither of them could produce the documents in this case. So I just want to be clear that the presence of an ABC affiliate here, owned by an entirely separate company, Hearst, does not mean that ABC is here in Massachusetts. They're a foreign company that has an agent for service process. They don't have offices and the like here in Massachusetts. Are they doing business here in the sense of transmitting ABC News programs through affiliates? I don't argue that. What I'm arguing is there's not the service, the fact that they're subject to service does not override the requirements of the statute.
Is there a distinction between obtaining records and obtaining a person's presence to testify?
The SJC has said in the grand jury case, the first case I cited, that the same procedures apply for documents as for witnesses.
Okay.
Thank you.
All right.
I think the cameraman had a Red Bull.
All the Rule 17 motions we have.
We're like,
Am I missing anything? Those are all the Rule 17 motions.
Everything the Commonwealth has proposed. Thank you.
All right, so we have some housekeeping matters that I just wanted to check on.
Who's going to vacuum,
I still have the
sweep,
motion to
sort the furniture,
continue
make
under
beds?
advisement. I need to see how we progress for a bit. The Commonwealth's
April
notice regarding the testing of the telematics system, where do we stand with that?
That's the additional chip off.
I know you had said you told
Distractions.
them that, Thanksgiving rather than Christmas to highlight big holidays, but where are we?
I did, and if I could have had it done quicker, I would have got somebody else. I have spoken to my expert numerous times. He has coordinated with the defense expert. They are heading to Texas on December 2nd.
Okay.
On December 2nd, they are going to test all of the chips, and there's an SD card that we expect has information on it. And then they're both scheduled to travel back to Massachusetts for December 5th.
Okay.
And they're going to do what's called a chip-on, where they take the chips, the SD card, they reapply it to the boards, they put it back in the modules, and they put it in the actual car, because there's different software which will give it even a more fulsome reading. And so after the December 5th event is done, I've asked my expert if I could have all results within a week. I have an uncertain response, promised to do his best, which really doesn't give a lot of meaning, but my hope is within 7 to 10 days.
Puts us about the middle of December for the results.
And I don't know,
Chip
Ms.
on,
Little
chip
or
off.
Mr. Jackson, if you have the answer to this. The transcripts of the sidebar conferences. Ms. Little, do you have any scheduling idea on when those will be available?
Yes, Your Honor, I do believe that Mr. Jackson had spoken with the court reporter and emailed the clerk's office with an update. It's going to be a little bit longer than initially expected. One of the reporters had sort of like a family emergency and needed some additional time. And so I believe, and I'll have Mr. Jackson correct me if I'm wrong, but I believe she needed until about 6 weeks to get the sidebar conference.
6 weeks from the November 13th date?
6 weeks from about a week after the November 13th date. Okay. Thank you, Your Honor.
Thank you. All right. Mr. Jackson, did you want to speak?
Your Honor, Ms. Little addressed the court's specific question about the transcripts, and that's as accurate a bit of information as I have, so I'll submit on that.
All right, thank you. All right, that is it for today. The Commonwealth is going to file a response to the discovery of communications in possession, custody, and control of the Commonwealth by 11/27, right?
Yes.
That's tomorrow.
Your Honor, I provided the defense this morning with a response to their motion. We'll file it with the court. It is a request that they made that is very labor and time consuming, but a very important task that I've been involved with. I spent many, many hours, and I need many more. We do have, or I have produced, or I have a production that I'd like to produce to the defense. I've shown them a protective order this morning to see if they were agreeable. I do not want to speak for them. If there is a protective order, I can turn over the first production that I've produced, and there is more to come.
All right, any objection to the protective order? I have not seen this document, obviously, nor the proposed order.
Right. There are a couple of issues related to this motion in addition to the protective order that I'd like to address with the court that I've briefly discussed with Mr. Brennan.
All right, I haven't read this yet, so I won't know what you're talking about, Mr. Kennedy.
So I believe you have read our motion, right? The motion that
I read your motion, I haven't.
Right, so it's just
Come
in
to the
relation
lectern,
to
sir.
motion, Judge.
All right.
Come around. Let's hear this.
Your Honor, generally speaking, we do not have an objection to a protective order as long as it is issued without prejudice, which I believe Mr. Brennan is in agreement with.
All right, is there one here, or was there a proposed protective order?
I have it right here, Your Honor. Mr. Brennan provided this to us this morning.
Yeah.
So I have not reviewed that, Your Honor, but I'm asking that the contents be allowed to be shared with the entire defense team, including our attorneys, our interns, and our client. I don't believe Mr. Brennan has an objection to that, but that would be our request with regard to the protective order, with the understanding that we could come back before the court and revisit that if we deem it appropriate.
Is there any objection to the sharing with the
There's no
defense team?
objection to the parties they would like to share it with, and I understand it's without prejudice.
Okay.
Yes, and with regard to the motion itself, Your Honor, I had come prepared with an argument for the allowance of the motion. Given Mr. Brennan's, the work that he's done in terms of trying to gather this material and get it to us along with the protective order, I assume that there's no general objection to the motion, so I don't need to be heard in that regard, assuming the court would allow the motion. But I would raise an issue for the court, actually two issues. One is that we were informed this morning that Mr. Brennan has gone through Mr. Morrissey's cell phone. Apparently there is one work cell phone and one personal cell phone. Obviously the personal cell phone becomes relevant because he used the personal email address to make an ex parte communication with the court. One concern that we have is that we were told this morning that with regard to Mr. Morrissey's text messages, not the emails, but text messages, apparently they're somehow remarkably set to auto-delete after 30 days. That obviously raises some questions for us, maybe the subject of a future motion, but more immediately, the concern is every day that passes, we're losing text messages from 30 days prior. So, through today, I believe...
Can they be preserved, Mr. Brennan?
I've been preserving them since I started the task last week. I'll continue to preserve them.
All right, so that...
Yes, that deals with that issue. So the only remaining issue, Your Honor, is with regard to the searches that Mr. Brennan ordered conducted or conducted himself, he had searched for all emails sent from Michael Morrissey's iCloud personal email to any emails that had a JUD in the suffix of the email address.
The significance of that is?
The significance is that would supposedly capture any ex parte communications with members of the judiciary or the clerk's office, and I appreciate that effort. However, we assert that it's insufficient. We believe that searches should be done of his iCloud email for the name Reed, spelled R-E-A-D correctly, or Reed R-E-E-D, which is how Mr. Morrissey typed it in his ex parte communication with the court. We don't know if he did that for the purpose of avoiding a FOIA request or if he just misspelled my client's name, but we believe there should be a search for both of those spellings. And in addition, we also believe there should be a search of his email address, the personal email address, for the names of the relevant witnesses, and we can give the court a list, for the names of all judges who have sat on this case, in terms of, is there an attempt to communicate with a judge on some type of personal email account, like he used a personal email account. And then also we believe there should be a search for any clerk's office employees for the same reason, both at Stoughton District Court where this case originated and this court as well. we have obviously reason not to trust Mr. Morrissey in light of his actions using this personal email account to make an ex parte communication. And we'd ask that a more thorough search be done for these types of communications.
All right, so why don't you continue to talk with Mr. Brennan, and we can have a hearing on this motion if there's anything that you still need on December 12th when we're back here for the docket hearing.
That's fair enough. Thank you, Your
Does
Honor.
that make sense, Mr. Brennan?
It does. I've taken extensive steps to do this myself to accommodate the defense in the most broadest fashion, and I'll continue to do that.
I think defense. I think defense is going to get all that they want. And it could be
So
good.
we will see everyone December 12th. So when do you expect to get me any written material you want me to have prior to the docket hearing?
Yeah.
Yes.
Your Honor, we drafted a landing and hearing motion. I need to review it. I'd like to get it to you by the end of the week.
That's great. I expect to be here at the end of the week, so that's great.
Thank you.
And your response by next week, Mr. Yannetti? Ms. Little?
Yes, if we could have it at least a week, Your Honor.
Okay. So I'll give you 10 days?
Thank you.
As long as that gets me before the 12th.
No problem.
All right.
Yes, Your Honor.
Yeah, if I can get it, as soon as you can get it. All right. Anything else? Yes.
I'm sorry to interrupt.
That's okay.
May I inquire if the protective order is going to be signed by the defense?
Are you going to sign the protective order, Mr. Yannetti?
I expect I will, without prejudice.
I have the materials. I'll just wait.
Okay. All right. So if you sign it, then I'll endorse it, Mr. Yannetti.
Mr. Yannetti
You have it,
now
right?
brings
Ms.
out his
Little
pen.
gave it to us just
I
now.
believe we just gave our copy to the court.
Yes.
All right. So this is the one that needs to be signed, and I'll endorse it.
Mr. Yannetti's pen
Do
is
you want to take a look at it?
only used for functional purposes, not for comfort. This is my signing pen.
All set.
Mr. Brennan, I know you have an electronic signature. I'd like you to sign this as well since you're here.
Yes, Your Honor.
You sign that, and I will endorse it.
It's they're reading before they sign. Camera guys all over the place. Pen left. Here we go. There we go. Zoom out.
Okay. Anything else?
Thank you.
No, thank you, Your Honor.
No, thank you, Your Honor.
All right. Thank you, and I appreciate counsel and the third-party record holders coming in today.
12/12, 9 a.m. All rise for the court, please.
12/12, 9 a.m. That's our date.
You are muted.
There's, oh wow, a free Karen Reed shirt right there in court. I'm surprised that's allowed. Goodbye. You know, I've seen a lot of pink, but the full-on shirt. So very little was decided today, a lot taken under advisement. So we turn it down just a little bit here. Yep, that's the one I need to go here. We're not gonna sit there anymore. All right. What is the protective order? This is a great question, Candace. The protective order is what they're talking about when they say we've got information that we're okay releasing to you, but we don't want it to go out to the public. There's stuff in here that should be protected. We'll give it to you in its entirety, but keep it safe. Don't release it. And so the defense says, as long as I only share it with my defense team and our our expert and our client. It's just going to be us. We're not going to post this on social media. He says, I'll sign that. Won't go beyond us, and then we'll get it. It expedites the process. Otherwise, the Commonwealth is going to say, we need to redact this. It's going to take weeks to get the parts out that we need to, not have go out public. But as long as you agree, then it's fine. This the Uniform Act is something that mentioned a couple times. Uniform Act is used to compel the attendance of a witness from out of state. So, you need somebody to come and testify. It typically is used in a criminal trial, criminal proceeding, which this is, but it seems weird subpoenaing the way they're trying to use it here. But it gives states the opportunity to have a process to bring somebody in and compel them to testify from outside where they normally have jurisdiction. And it helps prevent people from just crossing the border saying, haha, you can't get me. You don't have jurisdiction here. This also works for grand jury proceedings. So, all right. Let's see. Where are we? We made it all the way to lunchtime, which is crazy. They're still going at it here. Everyone's still leaving. Photographer's bundled up. Must be cold outside. All right. So I think we're done there. All right. I'm so over this case. Sarah Beth, I am as well. But the next case is going to be different. It's going to be a different case entirely. I honestly even think so much that the next case it's going to be almost unrecognizable from the first case. I think what's going to happen is the state is going to come in with a different theory of the events of how it happened. Not substantially. Obviously, they're going to put Karen Reed's car there. It's still hitting John there and backing into him. Things. I think some elements of that are going to be the same, but the problem is the story they concocted, the pieces they put together, did not fit the facts during the first case. They had some hard evidence issues. They need to come up with a different theory of events that fits the facts. So you don't have FBI people saying what the state says happened could not have happened. That's a problem. That's a problem for them. So I think the new trial is going to be very different. I think they're going to spend less time trying to prove certain members of family weren't involved and spend more time trying to prove that one specific person was. But obviously they're doing this fishing expedition, which, yes, I can see they're allowed to do that. It seems a little concerning that they're fishing and casting the net so widely, so close to the trial date. This is a murder trial. This is years in, and we're still just throwing our nets out there to see what we can find. That if I was the Commonwealth, I'd be a little worried that I don't have anything. There's no guarantee they'll catch anything, even if the judge allows them to get all those phone records. Even if that comes in, there's no guarantee. And some of what they want it to prove, it can't prove. It can't prove who answered the phone and what they said. But very, 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 very interesting. All right. They need to prove their case, not disprove defense's narrative. Right. They spent way too much time on that. This needs to be a shorter trial in a big way, and I think it'll be different. How do you think they'll handle the Proctor issue? They've got to be up front with it. They've got to come right up front, and they need enough solid evidence that doesn't come through him to be able to stand on its own. It's going to be a different trial next time around. Especially if they get this new chip on, or the chips that are off. They did the chip off. Now they're going to put the chips back on. If they get more data there, this could be open and shut, like Karen, would you like to take a plea situation, or Commonwealth, would you like to drop the charges situation. That data, if they get more from that car, that could completely change everything on this case. So we'll find out I guess they say they're going to get information about mid-December. That's going to be after the next hearing. Next hearing is December 12th, 9 a.m. So it'll probably be a week or two after that information comes out. Let's see. There's so many sketchy people involved here. It's crazy. The cover-ups, the butt dials, the evidence collection. AZ, I believe you're prohibited from using Starlink on an airplane. I think it's against the rules. They will have issue with that. I think it would work in theory. Could point it out the window, but you might want to check the law first and then try it on a private plane before you give up before you become on the no-fly list for doing something on Delta that you shouldn't. But in theory, it would work, and it should work well. You've got a great view of the sky. Jenny, I wish that this next trial, which is going forward, okay, there's no indication that this next trial will not go forward. It's going to happen. I wish that it could happen without the drama outside the courtroom. I wish the courtroom steps and everything that happened outside the court could just go away. I just want to see it just from inside court, without the back and forth and the Twitter and the live from the pizzeria and the fights and the pushes and the allegations and the shouting. I want to just watch the case, just on the facts, and just see it alone. And especially if it's going to be a completely different case from the first time. All right, let's see. Yes, we do allow everyone to speak your opinions. We just ask you to do it respectfully, and we appreciate opinions that are different. I know we've got probably half people here think that Karen Reed should be locked up, and the other half think that this was completely a malicious prosecution, and that the state or some key families, prominent families, are at fault. So it's okay. It's okay to have either opinion. If you have both, there might be a problem because they are rather conflicting. You might have some issues there. But we just ask that you share them respectfully and allow other people to share them and be respectful of their opinions. And we can still be friends at the end of the day, even if we don't agree on this issue. Sloth Life gifted another membership. Thank you very much. I saw the first one that came through. That was very kind of you. Now that I admit, RA, I would like the outside the courthouse bullcrap would all go away. We just focus on the upcoming trial. Yeah. It's good stuff. Half are wrong and half are right, says Adam. Yes, but the point is we don't know which half are right and which half are wrong. We always think that we're on the right. Juries have proven otherwise, but wish we got access to federal cases. They would be wild. So much good stuff happening in federal cases, and bad stuff, honestly, that I think needs more light. If you guys can all write to your elected officials and tell them to change the law so we get access to federal courts, that would be much appreciated. Let's see. I have a couple things to do. I've got to go mail these things. The auctions from Ian Runkle's stream. I've got coins that need to go out. I've got questionable pins that need to go out. I'm not bringing you to the post office. I'm sorry. Thank you, Famous Amos. Appreciate it. You can get a media pass for federal cases, but you can't bring your camera in. I want the camera. I want the back and forth. We auctioned off a bunch of coins, and quite honestly, the purchaser doesn't know this yet. They thought they were getting one thing. I can't remember which one got what, and so I'm sending the full kit of everything I auctioned off to both people. So if you're here and you won, surprise, you might have thought you were only getting pins. You're getting coins and pins. You might have thought you were only getting coins. You're getting coins and pins. 2 sets we're giving out to everybody as a big thank you. That way everyone's happy. And I know some people wanted both and only got one, but we're going to reward the people that won the bids there on that case with a little surprise bonus. So. How's the poll doing? The poll's doing great. We're not going to talk about it anymore. I went back and saw chat. You guys are bad. guys are bad. I realize I might have contributed a little bit to that, a tiny bit, but not no more. Anyway, I'm also including the extra pins, the these guys like right here. You see this? Focus, focus, focus. It says my eyes are up here. It's a little spring-loaded pin. We got 2 of those and 2 of the deer hunting ones. Little Amber. We're including those as I'm sorry it's so late because I missed my Instagram notification that the addresses were available. So, well, watch. I have no idea what you're talking about. No, I have zero recollection of any issues stemming from me yesterday. I did think though there's probably room for those of you who are looking for an awesome side gig. I think there's room for a YouTube channel that's basically, I think Men at Work's already taken because that's like a band, but a channel just watching people do their job, preferably construction crews. I think there's a hunger out there for that sort of content. live Men at Work. I think I'm just saying. This could be your channel. A thirst for that could be a thirst. I was going to say hunger, but either one I think applies. And he wonders why we're 3 mods short this morning. It was a rough day. We did a live yesterday, watching the power pole be replaced in my front yard after it got hit for the 2nd time by a semi-truck. Well, it's been hit many times, but twice the pole has been hit and broken so badly they had to replace it. It's been clipped a lot of times. But finally, yesterday, less than a week after it got hit, they replaced the pole and moved it 6 feet over into my yard further, which not a big fan of, but it was going to save the problem of my internet going out every time a truck hits the pole. So it was the play-by-play that made the stream epic. I feel terrible because you guys don't know this, but after the stream was over, I talked to the crew. They were all standing around, just talking about their day. That was the last job for the day. And they all wanted to know what the link to the channel was. And they pulled it up. I think we got some subscribers out of it. They're going to watch, and I feel, I'm not sure. I didn't say anything that I wouldn't say like right to their face, but it was good. It was good. It was a lot of fun. Should charge them rent for use for your yard. It's in the right-of-way area. As a matter of fact, I don't even own that part of my grass. I'm legally required to maintain it, but it belongs to the city. So they can pretty much do whatever they want right there. Yes, I was driving and listening while the pole was being put up. Yes. I pay taxes for part of the grass, but doesn't own it. My lot is actually 2 lots, but one of them is just wide enough for my lawnmower. I don't know why they would even have this. It's not wide enough for a road. It's not wide enough for a driveway. It is a second lot, and it is pulling teeth to get my county to just bill me taxes on both combined. I want to pay taxes and just have one bill for my property tax and not have to dig up some other property ID and search out that to pay my $12 tax on the other part. Because I missed it one year and I owed the county taxes. So let's see. They cite me if the weeds on their land are too tall. They bill me if the weeds on their grass are too tall. I have to cut it down. But apparently they have to maintain the trees. I don't have to trim those because those go over the road and stuff. I guess I don't do anything with those. Can you put a small house on it? Like a dog house is the only thing that would fit, Bob. It's literally just a sliver. It has to have the lots combined. Maybe they'll combine them more readily if I tell them that I'd like to build on the other one. Let's see. Oh Yeah, I can't trim the trees. I've lost the privilege after the last time. The other one's only zoned for dog houses. Funny, I'm building my chicken coop. I say I'm building a chicken coop. I have the pillars for a chicken coop cemented in the ground on that lot. So that there will be a chicken house over there. That's the only thing that's wide enough for. All right, I'm not sure why we're still here. I have to go to lunch. I have to go to the post office because if I don't get these out today, I never will. All right. Are we getting chickens? Maybe, because eggs are freaking expensive. We might get a cow too. Need a cow because milk. 8 gallons of milk a week is adding up. It's my second largest bill, right behind the internet access, which I need to cut down as well. I need to trim. I think if I switch from Metronet to Brightspeed, they have a special where they give me 3 months internet access for free. I get the same speed I'm getting now for half the price. The only problem is, I talked to them and they said, we at any time might change the price. And as long as we tell you that we're changing it before we bill you, we're good. I said, so it could be $79 one month and $2,000 the next? They said, yeah, but it probably won't. Like, I'm not sure. But it's probably going to be a while before it goes up to what I'm paying right now with Metronet. But I just feel bad about taking Metronet and like undercutting. They just sent 6 guys to replace my line last week. And they did it in a hurry, like less than 24 hours. So anyway, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe until we go live again. After lunch, we'll do some court hopping. We'll look for a little bit that's happening here. We are in a short week because of the holiday. A lot of courts not in session, a lot of juries not around this week. It'll end here. This holiday season is a little bit weird that way, so a lot of court hopping this time of year. Good stuff coming up, though. We'll see you after lunch. Bye-bye.
Scratch all that. Oh, that was terrible. I apologize.